permitted, my lord.
দিদি ওই বোর্ডে এডি না জ্বালিয়ে দিলে কেউ বুঝতে পারবে না যে কোর্ট বসে গেছে, বোর্ডে এডিটা জ্বালিয়ে দিয়ে রাখুন।
My lord, may I be permitted, my lord? Your lordship, my lord. The handwriting expert in a post will has.
Can you please give it in your slip?
The
I have been upgrading matters.
No, my lord, here, my lord. While your lordship was in circuit bench, it was listed before my lord Mr. Vikabhuta Mitra. His lordship has admitted and fixed the date 6th today, subject to the convenience of your lordships, because
So you write that, I'll upgrade it.
I have given the order of
Give
the
it,
copy.
please give that. I have been upgrading matters.
And
on
I
the
have
basis
soft
of-
copy, and my lord, already it has been.
Please give it. I shall look into, because this oral mentioning, it takes a lot of time, much of the court's time. I am slow.
I really, my lord, I
A
really.
lot of time for me also to understand. So
That is all the same, my lord. Extended only for
Anything. It any.
write your ground properly. It is not appearing in the list. Tomorrow it will appear.
Lord, your lordship would recall, Lord, two children, Lord, visitation.
Mr.
Yes, I have
Kornhofer,
written,
write
Lord,
it and give it.
two children, your lordship has appointed special officer, Lord, it was done. Lord, 16th is the next date, Lord, for closing of the school. Lord, till date after that, Lord, I have not received any visitation. Lord, kindly, Lord, consider this.
I kindly mention, my lord, a small leave be given because the content application is supposed to be filed. My lord, the income tax department has not complied with my lord's order. The small difficulty that we are facing is the board resolution that is there. The name of the authority should be Nikunj Mundra, but his signature is Nikunj. But the filing section is saying, my lord, to
No, but if the signature is not matching, ask him to write the complete name, get a complete.
Lordship, may I have your permission to mention?
The original side matter, my lord, where my RERA escrow account has been attached, my lord, Shrachi matter, my lord.
It will appear on Friday.
Lordship, may I have your permission to
Friday,
mention?
2 p.m.
Or I don't think, maybe earlier than that, because.
My lord, earlier as well. My lord, the earlier the better, my lord, because my lord knows, my lord.
Lordship, may I have your permission?
8 तारीख है।
My lord, I'm grateful, my lord.
long pending, kindly listed the daily.
So please write your grounds of
Lordship, may I be
urgency.
permitted?
And Mr. Kejriwal, you are not there.
My lord, may I be permitted?
I delivered the judgment in your other matter.
My lord, this reason one, my lord. Yes. My lord, I tender my apology, my lord.
My lord, may I?
Permitted extension of interim order, my lord. For extension of interim.
My lord,
Lordship, may I be
my lord,
permitted
today is
to
the
mention?
last day of extension, my lord.
Give it extension, please give this.
Lordship, may I be permitted to
Today is the
mention
last day.
for
Can I come
upgrade?
here? Board?
Today. Tomorrow.
My lord,
Your lordship,
It will appear tomorrow. What is the problem?
your lordship, may I be permitted to mention for upgradation? It's running in the monthly list.
Grounds of urgency and give
1709.
it, madam. This is the
Much
usual
obliged,
practice
much
followed by
obliged.
the court. No oral mentioning. Yes.
my lord,
9th April,
Give it, give it, give it.
my lord, there is very urgency, my lord.
Write your
My lord,
grounds
my
of
lord,
urgency.
this is
I
the
will
third
let
time,
you-
my lord, I am mentioning the matter.
Whatever, even if
My lord, the
it-
7-1, my lord, if my lord will,
No, no.
my lord, the
No
7.
means no, please write it and give it.
Well, I am
Follow what I say.
Third time, my lord, because my lord,
Even if it is 10 times, 100 times, oral mentioning, I will not see. If it is not there in the grounds, I will not upgrade. Please mention your grounds properly. If I am satisfied, I'll upgrade. Otherwise, not.
may I have the lord's leave?
কি হচ্ছে দেখে নিন কি আছে ওর।
May I mention item number 125 of daily list. Yesterday it was not listed, so I mentioned. This matter before the NCLT will become infractious. This is a fixed for reserved for order by the learned NCLT. My right to WS has been denied. So this is very small issue, my lord. Actually, right to file WS to the supplementary affidavit of the bank has been denied. So here, my natural justice is violated. Justice.
Very well.
My lord,
If it
may I
is
mention?
fixed for orders, you should have come earlier. Why have you come after?
No,
it
my
being
lord,
fixed
actually,
for
your
orders?
lordship,
No.
it's my
I have the lord's leave to mention this matter
My
for
lord,
withdrawal, your lordship. It is item number
Withdrawal
124.
দিয়ে দিন to be mentioned.
My lord, may I mention a matter, my lord? My lord,
Please give
extension
your
of interim
slip of-
order, my lord.
Give
Today
your
is Friday.
slip of mentioning with your grounds of urgency early in the morning. Don't waste court's time. Write your grounds of urgency on a piece of paper. This is the 10th, 15th time I'm saying. Give it. I will go through it. I go through the slips every evening after going away from
My lord,
court.
it's expiring. Sorry, your lordship. See, my lord, WSC denied at the time of final hearing.
Please call করুন।
My lord, may I say, my lord, this affidavit he was denied. Item number 198, my lord. My lord.
Special officer by your lordship's group. Second time. If the reports are ready, not allow this permission.
I'll reach it, Mr. Kornhofer.
That I can.
My lord, may I pray your lordship? My lord, item number
72 and 73.
my lord, at that
73.
my lord, may I say your lordship?
72, 73 to be mentioned.
72.
My lord, I
272, 273.
my lord, sorry, my lord,
Sir, I have heard it.
this is my lord, in the record. WS is in the record. I will stop from relying to WS at the time of final
Very
hearing.
well.
But this is,
And I shall go through the file.
but
If
I'm
I
grateful,
find it
your lord.
urgent.
Item number 198 has wrongly come under the heading returnable motion. But it has to be come under new motion because this is the first time matter.
দেখুন,
But
ভুল
it has
হয়েছে
been come
ওটা।
under the
দেখুন।
heading
You
returnable.
sort it out.
Item number 198.
My lord, this is for the expeditious.
কালকেই ফাইল হয়েছে নিউ মোশনে
আপনি কল করুন না লিস্ট এবার।
আই এম গ্রেটফুল
Madam, may we permit to mention one item for extension of entry moral.
The list has been called.
I am put up.
Yes, sir.
My lord, this is regarding in HMA 24 case number 61/2025. Interim maintenance order of 30,000 is passed by the learned 7th additional Parasat. So this 30,000 order is 15,000 for the wife and 15,000 for the minor daughter. This order is passed even when I was complying with maintenance order of 20,000 rupees, 10,000 for the daughter, 10,000 for the wife in the domestic violence case. This was ordered by the second additional judicial magistrate, Bosidhat, in case number C67/21 in the domestic violence case. Now this 30,000 is ordered here. The ground that is mentioned by the learned trial court is that the opposite party, that is me, I could not show any proof of income for the wife. But the fact is that in my assets and liabilities, I declared the income level of the opposite party.
Show me the documents.
Acha.
What
lord,
have you declared and what
Page
has
number 45.
page 45.
45. This is the assets and liability that I submitted to the Honorable Trial Court. Page number 45, F, para 2.
Page 45,
45,
para 2.
para 2. Here I have declared the monthly net take-home salary is 43,720 rupees. 45.
Yes.
This is for your wife. And what is your income?
My income is 62,850.
Page.
Acha. Page is 42. Para F3.
F3.
Ah.
Very well.
This is what I have declared in my assets and liability.
Right.
But the Honorable Trial Court has considered my income as 62,850.
Very well. So lesser than what you have declared.
This 62,850 I have not mentioned in my assets and liability.
You have mentioned 68. He has taken 62.
62. This amount is considered from the written objection that I have submitted to the Learned Trial Court. And my entire assets and liability is not at all checked by the Learned Trial Court. And for the opposite party, I have submitted 3 months of salary slip, which is attached. Is page number from 53 to 60.
Page 153.
No, 53.
Page 53.
53. So here, page number 54, the joining letter is there. She is working in as a assistant teacher, which is recruited.
This has not been examined.
No. And next, page number 55, my lord, 55 and 56 is the recommendation letter by the West Bengal School Service Commission. This is a permanent post, my lord. And page number 57, this is the approval of the district inspector for the pay level that is approved by the opposite party. Page number 57.
Page
57.
Page 57. Page 56.
And from page number 58, 59 and 60, 3 months of pay slips were annexed.
Yes.
Page number 58, 59 and
60.
60.
Seen it. Yes.
If readability is the issue, my lord, so page number 62 has a clear, very clear readable format for the pay slip for the month of September 2025. Page number 62. It is actually the content of page number 60, but it is not that much readable. So I have annexed the same page as annexer C, page number 62. Here, my lord, the salary is clearly written
43,920.
43,720 rupees.
720 or 920?
Page number 62, my lord.
62 is showing gross salary 43,920. Acha, net salary is 43,720.
This is
Gross
for the
is
serial
43
number 1, Sarmishta Mandal.
Yes, it has two components. Gross is 43,920, net is 43,720.
Correct, my lord.
Yes.
So net
Next.
salary is 43,720 rupees, my lord. So all this I submitted, but still none of these pages
Have
are
been
actually
considered.
considered by the learned trial court, and it is mentioned that no proof of income is submitted by the me. Matlab, I have not submitted anything. Also, my lord,
Where has he said this, that nothing has been brought on record by you?
my lord, page number 15, 15. Page number 15, para 5.3.
Page number 15 of what? Of your
Total, whatever page number I have mentioned, there page number 15, which is actually the order. Page number 15.
You
kindly
refer to the paragraphs of the order, because I can
Paragraph is
understand.
5.3.
5.3.
Ah.
Yes.
Here it is clearly mentioned he could not show any
document.
document of
Yes,
income
I've
of his
seen it,
wife.
seen it, seen it.
My lord, here in the main order, just a few sentences I want to read it out. Page number 14, my lord, one page before, and para 5.1.
Para 5.1.
It
Yes.
says, I have heard both sides at length. I have also perused the statement of assets and liability filed by the petitioner.
So
The
not
petitioner is the
yours.
wife, not mine. But I also submitted the assets and liability as per the direction of Honorable Supreme Court. And I don't know, my lord, why that was ignored. Also, my lord, page number, next page, para 5.2, it says, line 4, the respondent husband is a salaried person, whereas he earns rupees 62,850 per month as on 31st July 2025 as per his own admission. Where from this amount is coming? My assets and liability says something else. So it is only the written objection which is considered by the learned trial court.
So in the written objection, you had written that that is not hurting you in any case.
It is not hurting me, but what is hurting me is the assets and
That
liability that I have submitted.
Your wife's income has not been considered at all.
And my lord, my 6 months of my life, I am running across different courts now because of the order for which, like, I had no fault. I followed whatever legal procedure is there, whatever Honorable Supreme Court has suggested me, that I have followed. Totally, it is ignored. And this 30,000 order had been passed, although I was complying an order of 20,000 rupees in the domestic violence case. My lord, this is the bank statement. This
Bank
shows,
statement not required.
my lord, that domestic violence case, every month I am paying this amount. So that is there for the last
Domestic violence case
1
order
year.
is there on record, not required. The domestic violence case is there, order is there on record.
No, that's not.
It is there. It is there, my lord. It's page number 13, para 3.5.
3.5. Yes.
3.5. This is the observation made by the learned trial court. On the other hand, the respondent is only a salaried person, whereas he earns 62,850 per month on 31st July 2025. The respondent husband is paying rupees 20,000 per month as maintenance alimony to the petitioner as per the order of the additional judicial magistrate, second court, Basirhat. So this is also observed by the learned trial court, 7th ADJ, Barasat.
Very well.
My lord, once this On 31st of January, she was recommended for this job. Around 45 days, on 18th of February, she filed this case telling that I don't have any source of income, so I am filing the case. Whereas the petitioner, opposite party was knowing that I am having a job, I am having the appointment letter, and 2 days after, she joined the school. And as per the guidelines of the Honorable Supreme Court, my lord, this is Rajneesh versus Neha. My lord, page number 62, declaration 2. Page number 62, declaration 2. I undertake to inform this court immediately with respect to any material change in my employment, assets, income, expenses, or any other information included in this affidavit. This affidavit is annexed by the opposite party in page number 73. She has signed, the opposite party has signed. So, as per the direction of the Honorable Supreme Court, she is telling to the Honorable Court, I will declare any change of my income status. And after that, she has got the job. She was knowing on 31st of January, I am having a job. After 45 days, intentionally she has declared, I don't have any job. And she has filed this case. 2 days after, she has joined the school. She is having a monthly salary of 43,720 rupees. And after that, almost 8 to 9 months after this order has been passed, and the opposite party has not felt any need to inform about her income status. So, my lord, this opposite party has not approached to the court with clean hand. And for last since 2021, this opposite party is clearly misusing this legal system to exploit me and to extract monetary benefit from me. My lord, also, from the same Rajneesh versus Neha, page number 36, para G, which also says, if during the course of the proceeding there is a change in the financial status of any of the party, or there is a change of any relevant circumstances, or if some new information comes to the light, the party may be submit an amendment supplementary affidavit which could be considered by the court. My lord, also a 340 was initiated by me to the same learned trial court.
That is different.
And before passing this order.
Very well. That is not part of the proceeding here. You are on the order which has been passed under section 24. You made your submissions. I'll hear him now. Yes.
My lord, it is the true fact. My lord, she got the appointment. My lord, the application filed on my lord 18th February 2025. She got the appointment, my lord, the 20th February 2025. So before getting the appointment, she filed this application.
Well, one thing is after getting the appointment, she should have informed the court that
lord,
this is my income.
One thing, my lord, they have annexed everything, but kindly see the my lord, the written objection in page my lord, the 27.
Page 27.
Oh, sorry, my lord, page 35, my lord, kindly.
Page 35.
Paragraph 22.
Paragraph 22.
My lord, that since the February 2025, the petitioner has a job, her exact monthly salary is not known, but yet approximate monthly salary would be in the range of 80,000. But he annexed the document, but he submitted exact salary has not been known to me. But subsequently, this document has not produced before the court. Well, I do not know how he get the statements of this, but it is the fact he got the appointments. But second thing is
he has also falsely alleged, but in any case, it is not your case that you are not earning.
No,
it is not your case. It is not your case that you are not earning. Therefore, in such circumstances, you are obliged to bring it to the notice of the court that subsequent to the filing of the application for alimony pendentility, I have secured a job and I am now gainfully employed. Now, this fact, if you have suppressed from the court, then that is sufficient for the court to annul the order.
My lord,
granting you
one
alimony.
thing is that at the time of filing this application, my lord, he is not.
Very well.
Subsequently,
At the
thereafter,
time
my
of
lord,
filing, I am with you that at the time of filing you were not in the know of it, therefore you did not file the documents. But while the proceedings were pending, you got the appointment. At the time of passing of the order, you knew. At the time of making arguments, you knew. At the time of the when the proceeding were being, the carriage of the proceedings, you knew. All these times you suppressed. Now all of this can be washed away.
No, my lord, I am not. I am telling my lord, this is not the suppression because the document is there. My lord, the learned code below that has not been, my lord, disclosed by the petitioner. There is the salary.
Very well.
That is, my lord,
that is oath versus oath. That is oath versus oath. That is not going to take you anywhere.
But that's
the
why.
moment it comes to the notice of the court, and how will you justify the court's observation that he has not produced any document?
Yes,
He has
that is
produced
the fact,
Now,
my lord.
then on all counts, why should this order be not set aside?
My lord, one thing is, my lord, the only insufficient income is not there. That is, he is earning 2 lakhs.
He
This
has
my lord,
not-
this
he
is
has
the
not
dispute.
addressed
Yes,
anything.
yes.
He has just come to the conclusion on the basis of his own observations, which are absolutely contrary to what is there on record.
My
He
lord,
should have gone by the records.
I am bringing one thing, my lord, the remand back the matter for the fresh hearing because, my lord, the document is there. My lord, the matter should be heard in afresh because otherwise, my lord, there is no suppression because my lord, everything is one thing is the, my lord, conduct of the, my lord, the petitioner is that for that reason they filed the criminal case.
Very well, that I am not going
That
to
is, my lord, they have annexed it.
I am not going to comment on that
My
because
lord, the daughter is with me.
My lord, please allow me to submit on this.
the sentence which the
Yes,
court has begun with.
Yes.
I am not entertaining any
Yes, yes.
observation or any proceeding as regards you making any false statement or the petitioner making any false statement. Those are proceedings out of the purview of the court because today my jurisdiction only is confined to the order which is challenged before me. So far as this is concerned, I find that this order is perverse. It has to be set aside. Yes, sir.
My lord, on this, my lord, this written objection was submitted in the month of September. I filed all these RTIs and that school was not replying to me. So when I filed this written objection, at that time also, the RTI reply was not received by me. Only this joining letter I found, they replied. So the salary related information they was not providing me. So I was forced to write letter to the district magistrate of that. After that, district inspector of the school, then only they replied all the salary slip.
Very well. I am setting it aside, sending it back for fresh consideration.
My lord, that assets and liability for both the parties.
All the documents will have to be considered afresh.
My lord, if it is sent back to the learned court again, then again, like I have to roam around this district court of Barasat. Again, in the DV case also, this order is based on the level when wife was not earning. Then again, I have to go back to Basirhat also.
No.
My lord,
that order is not being interfered with.
Yes.
That we are paying. In this order, I'll clarify that the court will take into in any case, it is clarified in Rajesh versus Neha also that it is one alimony which is to be paid, which will include the other also.
No, I am praying if my lord,
pay two amounts.
I am praying from the my lord if you can pass order today itself for the maintenance because assets and liability
I will
for
have
both
to
the
assess
parties.
evidence then.
Yes, yes.
I will have to assess evidence which is not the jurisdiction of the revisional court. Appreciation of evidence is not the jurisdiction of the revisional court. That can be done in appeal. I don't have appellate powers.
My lord, tomorrow that date is there for execution. So this,
Today.
okay.
Execution
So I'll get a copy of this order today, my lord.
Even if you don't get
No, I have informed already.
Okay.
লিখে দিন লিখে দিন
This is my affidavit of service.
Lord, in asking. Lord, only one thing, Lord, I have instructions to appear on behalf of the opposite parties. No, Lord, kindly Lord, takes it up to me.
I have served the copy. But I have served the copy, affidavit of service is there.
If it, Lord, I have received the
Earlier for
telephonic
first an
instruction,
order
Lord.
to serve the copy, I have served this copy.
Lord, I have received the telephonic instruction today, my Lord. Kindly Lord, takes it up tomorrow. Lord, ask.
For the opposition party candidate, sir. I'm led by Mr. Saran Chatterjee is appearing through virtual mode.
My lord, I am appearing for the opposite party.
This revisional application has been preferred by the petitioner, my lord, against an order of alimony in pendenti lite. Here, my lord, first is my income has not been considered by the learned judge. My learned judge directed me to pay rupees 27,000 per month to my to the opposite party, and in addition to that, 1 lakh rupees to regarding the litigation cost. My case is this, my lord. My income has not been considered by the learned judge. Yes, my in my affidavit of assets. My gross income is 56,680, and this amount has been deducted because I have a loan. Yes, my lord, this is my salary slip, my lord. Lordship. Oh, Lordship, this is my affidavit of assets, my lord. Affidavit of assets, my lord. Yes, no, because it has been changed, my lord. The previous lawyer has not been annexed it, my lord. Salary sheet জজ সাহেব দেখবেন না বলেছি তো, দেখবেন না জজ সাহেব। 56,000 and 19,000 something has been deducted. 90,000 and odd should be deducted because I have to pay EMI. So that my income is regarding the 30,000 and all. And my another case is this, my lord, this marriage is not the valid marriage, in the eye of law, because this marriage was taken place by she has not been disclosed regarding her previous marriage, which was in existence and still in existence at the time of the marriage. Yes. And number 3 is this, my lord. Yes, lordship, I'm my written objection. Yes, lordship. এটা কার্ড ফোন ফেলে গেছে না? Yes, no, yes, the previous lawyer has not annexed all this. This is my lord, change brief, my lord.
Mostly the difficulty is that neither of the pleadings have been annexed. Only the impugned order and one affidavit of asset has been annexed.
Yes, and yes. দাঁড়া যেখানটা বলেছিল ইনকামের কথাটা ফলো করেছে। Two weeks, my lord. Within 1 week, within 1 week I can file. Prepare. অত সোজা নয় জিনিসটা। Opposite part. And my lord, tomorrow is the date fixed before the executing court. My lord, kindly, may I pray for?
Kaushik, they are not paying the maintenance and I have to
No,
file
my lord,
execution
regularly I'm
petition.
paying the maintenance, my lord.
My
Regularly,
instruction is that
Such time it is set aside.
it's very irregular.
There is one
No.
CAN application for the litigation.
Well, no copy of the has been served upon.
There, CAN is not there in file. There is no stay on the execution. You proceed. Next.
Deeply obliged.
I'm appearing for the petition.
What happened yesterday?
Well, yesterday they have not yet passed any order. I suppose possibly my senior friend has
Another 15 days. Now you don't say that you have not got opportunity and all. You
no,
contest it in
I
the
shall.
manner.
But my lord, today, my lord, where I last stopped, my lord,
Before he starts, last time he said that he has made an application in. Let him show that there is no
my
application.
lord, I can bring that. My lord, they have accepted. They are recording in the order. There is my application. My lord, they do not give a receipt copy.
It is not here on
To argue on this case, why the injunction should be granted.
Yes. My lord, kindly, my lord, I am not repeating yesterday's submission, my lord. I just, my lord, need to show now, my lord, two things. My lord, what transpires from my lord and my senior friend is, my lord, that 2017, my lord, first contention is not automatic renewal. My lord, my endeavor today would be to show it's an automatic renewal. Second, my lord, a pertinent question fell from my lord, which I'm obliged to show that I have made a prayer for renewal before the authority prior to that expiry, or my lord, after the expiry. Personally, I've made. I have shown yesterday. My lawyer has made a representation. Now, my lord, thirdly, that they have already granted me a permission with regard to the transfer. My lord, these are the three things, my lord, I would show today. Now, my lord, kindly first turns to, my lord, the prayer which I have made, kindly turns to page 72 of the revisional application. Maharaj got that page 72?
Just a minute.
Page 72.
72.
My lord, this is a letter dated 17 July 2025. Maharaj got that, my lord?
Page
72. Yes.
Yes.
Now, my lord, this is a letter dated 17 July 2025. My lord, without troubling with the entire, it refers to several previous letters. The last paragraph of that letter. My lord, this is written by A. Banerjee, Alok Banerjee, the original lessee, the plaintiff number 2. Now, my lord, 5. In light of the above, I kindly request that all future correspondence related to the said property be addressed to Srimati Sapna Singh, who is the plaintiff number 1, and the leasehold rights be formally transferred and extended in her favor in accordance with the Government of India Ministry of Defence Policy Letter 10th of March 2017. So, my lord, this is the letter, my lord, which the original lessee, who is one of the plaintiffs, and claims the right that he is also a lessee, because they are saying that we have not extended. The original lessee himself writes that please enforce the notification of 10th March 2017 and extend the lease in favor of the plaintiff number 2, who is the subsequent transferee. Now, my lord,
that is your request.
That's my request.
They have whether they have acceded to this request.
Yes, that from the notification I will show they have accepted and it's mandate. Now, my lord, second is, my lord, the permission, my lord, which they have permitted me to transfer. Now, my lord, kindly takes up the impugned notice, my lord, which is under challenge, on which, my lord, there is a prayer for permanent injunction made in the suit. That is at page 91.
Page 91. Yes.
Now, my lord, paragraph number 3. May I just place it, my lord?
Yes.
Further, on receipt of your repeated request by your letters under reference and notice sent by the assigned advocate by later dated such and such, this office has strictly advised you not to execute the lease in favor of any which will be treated as unauthorized sale, purchase, and will violate the lease terms and condition. We are pausing here for a moment. My lord, this statement is also wrong. Necessary documents for
Why do you
considering
say this statement is wrong?
the subsequent lines will say that. Necessary documents for considering permission of the competent authority for the requested sale transfer were desired. This office letter dated 9 June 2023 and the same was furnished by you letter dated 12th of June 2023 for further action. The due lease rent was also realized from you letter dated 1/11/2023. Option for surrender of the leasehold right were also offered to you with a letter dated 30/9/2024 with the restriction of sale transfer only of the leasehold right of the structure standing on the demised land up to 19/7/2025 only were imposed. So they say they allowed me to transfer only the structure.
Yes.
So now, my lord, kindly turns to my transfer deed. What I have transferred. That is starts at page 73.
No, but please come again. Where do you get that they have said that only they wanted to transfer you this, wanted you to transfer this structure, not else?
My lord, the last of the third paragraph, from 3 sentences stop, the due lease rent was also realized. What has got that? 30th September.
Lease rent was also realized from your end.
The due lease rent also realized from your end, letter dated such and such. Options for surrender of the leasehold rights were also offered to you letter dated 30/9/2024 with the restriction for the sale, transfer of only leasehold right of the structure standing on the said defense land up to 19/7/2025 only were imposed. So I could have transferred only the structure. And my lord, for my lord's convenience, it is their document. Kindly seize this letter which was there. My lord, paragraph 3 of that. This is the same letter, my lord. 30th September. It may be strictly noted that the only leasehold right of the structure standing at lease site being such and such be transferred. GOI MOD is the absolute owner of the land. Both the lease transferee will be assured to protect the government rights. So it's only the permission was granted to transfer the structure. So, my lord, in pursuant to this, my lord, they say I have affirmed an affidavit to the extent I shall abide by whatever comes in 2017 notification. After that, this affidavit was also
the extent of your transfer of the.
Yes, kindly takes up my transfer deed. It starts from 73 and the relevant portion no. Well, at 79. Be it noted that
yes.
And furthermore, in the said lease deed, I must also indicate page 78, the second paragraph, the last 3 lines, together with all right, title, interest which the lease transferor have as per the existing lease deed over the aforesaid leasehold land and all other rights of the easement. So, as on date, it was existing. Whatever existing right he had transferred the structure along with the existing right, nothing more, nothing less. So, this permission was granted in my favor. Now, apropos this, my lord, they take a declaration not only from me, but also from the subsequent transferee. My lord, that declaration, my lord, will find.
This does not form part of the lower court record.
This supposedly, because it refers to that 39 September, I have taken the copy because I have to take note of whether it forms or, but it's in the impugned letter itself. So, my lord, I have obtained a copy also of that letter. It is their document.
No, it was not placed before the law.
Don't look into this, but it refers to the impugned letter in it, which is part of the record.
He is relying on this that permission has been granted.
For a clear paragraph. The
Permission
paragraph
has
is
been
there in the
granted.
impugned letter. The paragraph is there in the
that letter will not grant.
That paragraph is quoted there.
Kindly see, somebody grants a letter, grants a permission. A subsequent letter which says that by that letter you have been granted permission will not be the proof of grant of letter.
No.
The original
For the
letter will
purpose
be
of-
the proof of.
At the prima facie case stage, you don't have to prove prima facie title.
My lord.
Prima facie case stage is different.
Then, my lord, kindly takes up first affidavit which we have given apropos, which also refers that I have furnished all affidavits. Kindly takes up page 64 of the, my lord, revisional application.
Permission. भाई पेज मास पढ़ाना पड़ा खूब
My lord is looking at page 65, my lord.
And what is your reply to this letter, 30th September? Because
My lord, we have abided by that because they took an affidavit of
it is
undertaking.
not a question of abided. 2A asks the reason also.
Yes.
2A
Yes.
asks for certain reasons. See 2A, the reason
Yes.
for such hefty amount for a very less period of the leasehold right, that is up to 19th of July 2025, which is less than a year, may be justified. Now, what is the reason for this? And where is the justification for that?
My lord, before
Because
this
the-
justification comes in,
the last line,
yes,
that only the structure be transferred. You cannot read it divorced from the first paragraph, because you know this is a defense area, defense project. I'll go strictly by this.
Absolutely.
Naman phase 2. Now somebody for a month, he presumes that yes, it will be extended, and with the presumption he transfers. That is
No.
not the.
I tell your lordship, my lord, apropos this, they seek a affidavit of undertaking from the purchaser for the transferee, which was submitted before them. It's
Where
not
is-
that.
Where is that they have sought?
Yes, kindly takes up, my lord, page 64 first. This undertaking was submitted.
So this is your submission.
No, this I am forwarding the undertaking made by the subsequent transferee as sorted by them.
Where do I get that this was asked for?
My lord, kindly takes up
Because-
the impugned letter. In that impugned letter, they refer to all actions which I have abided by.
You have abided by, or the actions which you have taken? Because
No, abided by.
Abided by will mean that they had asked for it.
They have asked for.
So show me that the
Yes.
language reveals that you had asked for it.
Kindly takes up the impugned letter for 1 second, my lord. Impugned notice.
Page
91.
Page 91.
My lord, from that necessary document, third paragraph.
Yes.
Necessary documents for considering permission of the competent authority for the requested sales server were desired by office letter dated 9 June. This is at page 66 of the revisional application, this 9 June letter.
Yes.
And also, and the same was furnished by you with a letter dated 12 June for further action.
Yes.
The due lease rent was also realized from you while letter dated 1/11. This due lease rent will also.
This undertaking which you had given is of which date?
Lord, this under 12.
It is not of 12 June.
My lord, June undertaking, my lord will see. Kindly
Because
takes up.
this refers to those documents which were furnished on 12 June.
Yes.
And this undertaking bears a date of November 24. So it could not have been furnished on 12 June.
12 June, my lord will find at page 69.
June is an affidavit.
Affidavit.
Yes.
Pursuant to, my lord, their demand.
Where do I get this?
My lord, that is at page 66. Kindly takes up. 9 June 2023.
Page 66.
Second paragraph, my lord. Further,
This is that so that they can proceed wait for
grant
this
permission.
office for further necessary action.
Yes. So for necessary action, I have abided by, I have furnished
But
undertakings.
whether the necessary action in the form of a permission was given to
Now this is then, my lord, they refer to 30th September letter where they say I have allowed you to transfer only the leasehold structure in the impugn notice.
And what is there?
But the lease purpose, my lord.
What is there in the notice which you have impugned in the suit?
That notice, my lord, kindly turns once again, my lord, page 91.
Page 91.
Now, my lord, they say after saying that all compliance, they have allowed this permission for structure, kindly takes up the paragraph for which they terminate the lease now. Now, my lord, kindly takes up paragraph 7. My lord, whatever they have stated in it, Naman, whatever, kindly says paragraph 7. The full term of the lease has already expired. The possession of subject lease land bungalow standing on defense land can be taken over the defense purpose. Now, their contention is as it has expired full term. So, therefore, we are entitled to take it. Had it been a case that it was existing, the term of the lease, they would not have taken it. The necessary corollary of the sentence is that the full term of the lease has already expired. The possession
has some other meaning. Nothing has
I have a
direct meaning.
Anything to it? Let us read what it says.
Yes.
It has expired because this has been issued after expiry.
Yes.
Now, it doesn't mean that they could not have issued it.
Kindly bear me for a minute. The full term of the lease has expired. The possession of subject leased bungalow standing on defense land can be taken over for defense purpose. So, my lord, plain and simple meaning, no corollary.
Very well.
Well, full term has expired. They can now take over for defense purpose.
Yes.
This is their case. Nothing more, nothing less. Now, my lord, to show prima facie satisfaction, two things I have already shown. That the permission which they have granted, and my lord,
I don't think so, because the permission was yet to be accorded.
That apart.
I think that is
that apart. My lord, even if my lord is of the view that that was not the sole permission because there are two other paragraphs added to it. But in my respectful humble submission, paragraph 3 is independent of its nature. My lord, they had a right. And my lord, I will show from the notification, my lord, itself, which they themselves say is binding on them. Now, my lord, the notification part will come in, where they say, my lord, this is permissible. This is permissible as per the notification, as per the origin.
Permissible, but whether because it is permissible you have been permitted to do or not needs to be seen, because there are certain things. They also say that it needs to be explored, whether you should surrender or not. That also needs to be explored.
No, that's an offer.
So
kindly marks the word, my lord, this is an offer.
No, it doesn't say so. The notice.
In the impugn notice.
Impugn notice may say, but 30th of September 2024 says that you will also be able
my
to
lord,
enable.
B, my lord, kindly text B. My lord, B is that offer. Further, it also revealed from the sale deed that you have mentioned the reason for selling of the is due to inability to maintain structure standing on the leasehold is in inhabitable condition. You will also be able to bear the lease rent in future under such an option for surrender. So there isn't just an option given.
And the extension is for structure, or the extension is for lease in entirety?
Extension is for lease, not
lease
the structure.
In structure or lease in land with structure?
Lease of land. Will not buy the lease.
Then again there is a problem, Mr.
No,
Chatterjee.
Will I tell you, give me. I understand what is falling. Will the original lease deed. This is the extension of the original lease deed. Now, will original lease deed granted as vacant land. Now, will permitted us to create a structure. We have created a structure. We are residing there. Now, Millard, this has a tenure of 90 years.
So, lease of the structure cannot outlive the lease of the land.
So, they are saying for the timing you transfer the leasehold right of the structure.
So,
and
lease
this
of the
after
lease of the land will be extended. Lease of the structure will not be extended because
no, it is automatic. It is deemed.
Can't be automatic.
No,
can't be automatic.
Today
because you have to read this also. Strictly noted that only leasehold rights of the structure such and such, because such and such is the absolute owner, both, because this has to be read in conjunction of the short period which they have mentioned twice or thrice.
Yes, well, I understand.
Only a few months or maybe a month.
Well, there is no doubt that the extension.
So they suspect something foul.
I tell you, Lordship, Millard, if they suspect foul, Millard, then they in the notification itself they could not have said it is permissible.
Which notification?
2017 says permissible. The original lease deed says it's permissible. Millard, in both this,
It is permissible.
In any case, you can take this defense before the
Now, my lord, to
assessing
that,
the-
my lord,
the
if I make
district
a prima facie case to this extent, that, my lord, I was a lessee, there is no doubt. My lord, before the expiry of the tenure, I sought for a permission of transfer for reasons cited. They sought an undertaking from me. I furnished, they obtained the lease rent which was due. I paid that, and I also transferred only the structure as directed by them. Nothing more.
Because they knew that so far as the lease
So,
is concerned,
so, my lord,
the
today,
lease is
and
for
my lord,
land only, not for the
so
structure.
today, my lord, as on that, my lord, I also prayed before them, kindly extend the lease in favor of the subsequent transferee, apropos the government notification. Apropos the government notification. So, my lord, in the lease deed also, my specific contention is everything will follow as per what is decision is being taken by the government. Nothing more, nothing less. So, my lord, it is not that I am exceeding my leasehold right. I am nothing doing behold the law or beyond the law. Now, my lord, today this notification which they rely upon, my lord, yesterday's kindly takes up the 2017 notification. I have annexed it at page 100, but my learned friend has supplied a fresh copy, my lord.
Yes.
Now, my lord, I have analyzed this notification to befit his argument that this is not automatic. Now, my lord, first I say it is automatic on reading of the two notifications itself. The 2022 which was supplied by my learned friend and 2017 itself. Now, my lord, this 2017 notification is of 10th March 2017. So, my lord, it is contemplating few leases which have expired and which will expire. Now, my lord, it has an object part. The object is to regularize. So, my lord, if I divide the notification into two parts, object, measures, and the procedures, then, my lord, the object is to regularize. To regularize, the government takes interim measures. Now, my lord, this interim measure, my lord, yesterday I have cited at paragraph A and B, the interim measures which have been taken. Now, my lord, interim measure, may I read that only, because that is my sheet anchor would be. All leases given under the Cantonment Code 1899, 19112 and CLR 1925 and 1937, whose full term has either expired or is expiring before 31/12/2018 will be extended till 31/12/2018 subject to the conditions given in succeeding paras. So, my lord, this extension will be extended is a future past perfect tense, which says that those which have expired will be extended or will expire will be extended. So, extended is a past tense attached to a thing happening, because this notification is on 10th March. Second, this happening will be automatic if these conditions are fulfilled in the succeeding paras. Now, what are these conditions? Or rather, these conditions are not prevailing. Now, my lord, what are these conditions? Eviction order, which is not the case in our case. 2, extension of such cases will not be permitted where transfer, sublease or assignment lease were made after the expiry of full tenure. My lord, my case is pre. So, my lord, at best they have
not apply to you.
Doesn't apply to me. And my lord, the next STR, my lord, they have not demanded. So, my lord, I am not in a position to pay because it is their duty to demand. Now, my lord, rest of the paragraphs, my lord, paragraph 5 is important here, my lord. Wire tailorship, paragraph 5, bullet, the last bullet. To answer one query of my lord, that NAMA project. For the expired cantonment code lease site, because this is the paragraph 7, your term has fully expired. For the expired cantonment code lease site located outside civil area, my lord, my civil area, there is no doubt on that. Bungalow area, the government shall retain the right to resume the site anytime as per commandant code lease condition if such is required for defense of public purpose. So, my lord, firstly, it has to be outside the civil area, bungalow area. My case is within the civil area, bungalow area. So, they take that lease term expired, I require it, give me it. It cannot happen as per this notification itself, which is binding upon them. It is their notification. Now, my lord, kindly. Now, furthermore, I read this because to obviate this in the subsequent policy decision which is being yet to be taken, one condition they sought to be added in future lease deeds. In case of expired leases given under the CLR and located outside civil area, a resumption clause will be added whereby government shall have the power to resume site before 31/12 if required for any defense purpose. So they insist on adding a clause in outside civil area, not in inside civil area. Now, my lord, kindly takes up the procedure part. Now, my lord, this procedure, which my learned friend has heavily relied yesterday, but kindly takes up this cannot be read, my lord, in thus one clause cannot be read in isolation, because this has very important connotations, my lord, I must say. My lord, first I.
Yes.
CEOs stroke DEOs. DEOs is the Defense Estate Officer. Shall forthwith prepare a list of all such expired leases and assess arrears of lease rent from the date of expiry of lease and annual rent payable by the lessees. The demand notice for payment of arrear and annual rent shall be sent to lessee stroke unauthorized occupant within 3 months of issue of this letter. So first is, my lord, on expiry, they are presuming a lessee stroke unauthorized occupant a demand letter for the arrears to be sent first within 3 months. CEO, Cantonment Board and DEO shall give wide publicity and also publish public notice in the local newspaper to this effect, while arrears of lease
What do
rent.
you want to come at that straight? I've read it.
Second,
many times.
the
Yes.
lessees unauthorized document who fail to deposit due arrears of rent within the 3 months of issuance of demand notice shall be deemed as unauthorized document, and action will be initiated by DU under the PP Act. So, military is only on milord failure to pay the arrear demand. But this is what STR is. So thereafter, they say they have confined the application of the PP Act in respect of who failed to pay the arrear rent within the due time. In case of this of expired leases. Now, my lord, kindly takes up with respect to subsequent transferees even. My lord, there is a clause in the procedure.
Very well, it's not applicable to you.
Not applicable to me, and my lord, I say, my lord, this 4, which my learned friend on the last occasion relied. Extension of leases will be done in Schedule 4. My lord, what is this Schedule 4? What are they? My lord, this is the rule, my lord, Cantonment Code Rule of 1937. I've taken a printout. I'm just turning over. My lord, Rule 4. My lord, kindly have a look. My lord, this is the format of a lease deed which will be executed. Nothing more.
That was my whole case, that this has not yet been done, you don't have any right. Had this been done, that is my whole case.
But the policy is yet to come, they are executing anything.
He is not seeking specific performance of execution of a lease deed. He is seeking that it is automatic. He is not saying, I am saying that it cannot be automatic.
I'll come to you, Mr.
That is
Dasu.
why
Let him complete.
Yes, that
now, my lord,
relied on this.
kindly takes up, my lord.
Mr.
I'll be very quick, very quick.
Cannot go on for the whole day.
Yes, yes. Now, my lord, kindly directly comes to, my lord, B of that notification.
Yes.
B is, my lord, where they intend that which are permissible. But as I was submitting, my lord, transfer, sublease, assignment, leasehold.
Compounding, that is on their wish.
This is permissible.
You cannot take it as a
Permissible
right.
compounding. And, my lord, they have permitted, I have shown, I'm arguing on both angles, my lord. Now, my lord, kindly take C. My lord, this is important, my lord, I will just read 3 lines of it, 4 lines. 3CA. My lord, this is where they, my lord, intend to take under proceeding under PP Act. If the adjoining land has been encroached upon by the lessee, the case of the encroached land shall continue to be dealt with eviction under the provisions of PP Act, while the proposal for renewal or lease to the extent of unauthorized lease, authorized leased area should be processed. So, my lord, whose leases have expired, those are not unauthorized occupant.
Merely because this says you cannot say that, because that the act
No,
says Act says so. If leases have expired according to the
after
act,
the act, my lord, the government knows that after 90 years, my lord, a problem is to come. So, my lord, this policy decision is binding upon them. Now, my lord, 2022, my lord, kindly takes up, which they have cited, my lord. 2022 notification. kindly takes up, my lord, the first page, my lord, the paragraph 3 of the notification, my lord, is read after para 4 of the MOD. This would be added.
Just tell me the point. Don't go through it. It is taking a lot of time unnecessary. I have read it. You tell me what you want to say.
Yes. 5.5.
Yes, 5.5.
Based on the self-declaration certificate, an automated provisional sanction. So, my lord, this is automated. Now, my lord, what is that self-declaration? I could not, because a impugn notice has come in that your after full term has expired, please move out within 7 days. I do not have a chance to that. Now, my lord, so, another thing, my lord, this in this notification itself, my lord will find kindly takes up that self-declaration affidavit which is annexed to it, my lord.
Yes.
Mr. C, no? My lord, kindly takes up Annexure A. My lord, kindly sees that if these 3 conditions are not there, it is automatic renewal. Because this is that self-declaration which they are seeking. My lord, first is no eviction order, there is no ongoing litigation, no transfer sublease after the full expiry of 10 years. So whatever is stated in 2017, I have to declare it by way of an affidavit. And then it's an automatic renewal. So, my lord, I could not avail this system because they have already issued a notice saying that you please leave within 7 days. So, my lord, I have to go for a litigation saying that that notice itself is impugned, bad. You cannot do this because 2017, by 2017, I am a lessee. I am continuing. So, my lord, his contention, this is not automatic, is absolutely false flat. This is also automatic, just a procedurally I have to apply online and furnish a self-declaration.
Very good.
Now, my lord, to this, if this is the factual scenario, my lord, today, my lord, I go before the civil court saying that declare my right as lessee in view of that notification, and my lord, to restrain them from giving effect to this impugned notice. Now, my lord, during pendency, the appellate court by the impugned order, my lord, I will not trouble my lord taking to the impugned order. The court says I want to hear them and says, since you have transferred, I have shown that transfer is why the structure was permitted. So that was again, my lord, something wrongly looked into. My lord, second is, my lord, in the meantime, when I'm in High Court, my lord, when we have moved first, my lord, they subsequently issued notice under Section 4. Now, my lord, this subsection 4 notice makes me to appear before them praying for adjournment. I'm not going to that, my lord. My lord has expressed in his mind, it is not before my lord. My lord is in difficult position to lay its hand on it. Now, my lord, if that be the position, my lord, today, my lord, under 1971 Act, my lord, I cannot make the prayer that the impugned notice is bad.
Why not?
No, my lord, I do not have a right of counterclaim. My lord,
sir, you can always have a defense. That
yes, I can have a defense.
Yes, so that will be because I am a lessee, therefore you cannot issue this notice.
Then
why not? Why
But
not?
I am
A
an
state
authorized.
officer is not supposed. A state officer is not a subordinate in that sense. A state officer is supposed to be an independent entity. He will decide as a judge decides. He's an adjudicator there.
Absolutely. Milord, that's why I say, Milord, my first argument is, Milord,
the question of you seeking a counterclaim in the nature of a declaration is only an extension of your defense in a different way. It is only the extension of your defense. You are projecting yourself as a tenant or a lessee, therefore you should not be evicted. And I am a tenant, therefore I should not be evicted. It means the same thing. You declare me first a tenant and then grant an injunction. Or you cannot evict me from here because I am a tenant. So it means the same thing. Why you cannot do this? I don't understand this. It surpasses comprehension.
Yes, Milord, today, Milord, my right of declaration of the notification, because they have
he may not pass a decree, but that if you can satisfy the estate officer that yes, your lease continues, there is no reason why the estate officer will still continue with the proceedings.
Give me 5 minutes. Milord, they are on 4 notice saying that they are of the opinion I am on.
There are even judgments to this effect that if you have this defense, first take this defense and then challenge.
Milord, two things. 2 arguments I will make. Milord, firstly, Milord, if I have shown before my lord prima facie in this case that, Milord, the notice itself is bad in law, this could not have been issued under no imagination.
As a civil court, the court will not injunct the estate officer from proceeding. Cannot. Because there is a bar.
Specifically,
In the,
my lord,
in the
41A
PPA
says
itself,
injunction can be granted. 41B
sir, this
says
is a special act. You will have to
15,
do by
section
this.
15.
It says
Civil
that
court jurisdiction is
yes, and
out.
no injunction can be granted. That is also I think
15,
I
15.
think
My lord,
that's
I know
there.
it.
দিদি একটা আনিয়ে নেবেন না এটা আমাদের নেই কেন এখানে নেই ওই কোচে ছিল
15, my lord, I've gone through that.
yes so
15.
so the injunction not to evict you except in accordance
No,
with law,
today-
how do you say this is not in accordance
Today,
with law?
my lord, I say I can pray for before my lord that the notice, my lord, which they have issued, kindly stays the impugned notice of the 6th August 2025, because that is not the scope of my lord PP under the PP Act. My lord, scope of PP Act starts by section 4 notice. My lord, if section 4 notice, my lord, in section 4 notice, I take a
Very well,
defense.
very well. Continue. Let us not argue on this. Continue.
Now, my lord, to this, my lord, my proposition is, my lord, relief modeling today. But I will show that, my lord, to cut short litigation. My lord, the basic principle, Honorable Supreme Court has even said that I will not. Paragraph about. My lord, I will just take, my lord, quickly, because my lord is consider paragraph 24 of this decision.
Yes, because it's motion bench. We cannot.
I understand. I understand.
The morning.
Understand. My lord, this is something very difficult and interesting also, my lord.
Everybody is now interesting after the vacation.
Saturday,
Saturday.
courts are
Saturday.
offering.
My lord, this is-
Want to take
have
a
it.
come on
You
Saturday?
agree? You agree?
But I am agreeable. If my learned friend agrees.
No, not in this matter, some other matter. Not in this matter.
Now, my lord, kindly takes up the last page of the my lord judgment. Citation. টা বলে দিচ্ছি. This is reported in 2025 SCC online, SC 633.
No, it's indeed interesting. No doubt about it.
Now, my lord, last 3 lines of the last page of the judgment. In our considered view, my lord has got that just. In our considered view, the molding of relief in this case is to shorten the litigation or not subject the plain schedule to vagaries of certain and uncertain documents. We are in complete agreement with finding recorded by the impugned judge. So, my lord, it's cutting short litigations. My lord, it is not about, my lord, why I'm saying, my lord, kindly stays the impugned notice, which is beyond the scope of PP Act. PP Act is based on section 4. The initiation is section 4. My lord, they are of the opinion I am unauthorized occupant. My lord, I say, my lord, their opinion, my lord, is based on whatever reason. But today, my lord, my case is that impugned notice, which is based on 6th August 2025, is, my lord, void, is bad. And not to give effect to that. My lord, if that notice is stayed in my suit, saying that in by virtue of 2017, you could not have issued this notice to a lessee who is in civil area, and you yourself says the lease will extend automatically. But a certificate which I could not make because you have already issued that notice.
Yes.
This is one. My lord. Paragraph 11. My lord, what I was just yesterday arguing, my lord, kindly takes up paragraph 11 of this judgment, my lord, 1950 or AI 1953, Nagpur 361. This is a full bench decision of Justice Hidayatullah, my lord. This is where, my lord, court says, my lord, in a proceeding, my lord, where, my lord, in appeal or, my lord, a revision, my lord, if it's inter se the parties, my lord, court must take cognizance of facts which have developed.
Paragraph
11.
1953.
I'm just reading it. A long track of decision has settled that an action must be tried in all stages on the cause of action as it existed at the commencement of the action. See such and such. Then, my lord, among also, no doubt, court can and sometimes must take cognizance
Mr.
notice of
Dasgupta, I'll
facts,
call
but
upon
that
you
is
next
done
day.
merely inter se parties.
Well, I'll take 2 minutes. My argument is very simple.
No, your simple argument will not do. I have to hear other matters also. You
So this
conclude
is,
today.
I'm concluding. Now, my lord, this is the inter se party subsequent, my lord, this recovery proceeding which has developed when I'm in 227. My lord, it's not that when I'm in trial court, my lord, hearing a matter before this honorable court, subsequent to that. Now, therefore, inter se party, my lord, taking note of to cut short litigation, running me, my lord, seeking a declaration that notice to be bad and, my lord, defending there. Both at together. Because if I withdraw this suit today, my lord, I have to say, I have to even challenge that notice to be bad before the estate officer, my lord, which is not permissible.
No,
Now, my lord,
you, in a sense, you are right, but Mr. Chatterjee, in order to avoid a notice, you need not always say that the notice is bad. You can always say that the notice does not apply to
my
you
lord,
because of
my
this fact.
entire endeavor is to, my lord, in such situation, my lord, to cut short litigation. My lord, it is not court's endeavor to.
Suit will,
No, I'm not now, my lord. Now I'm not praying for.
will protract the litigation.
No, my lord, I'm not saying, my lord,
Proceedings will cut it short.
only one line I will end my argument. My lord, I am not saying stay the recovery proceeding as 15 stands in the way, but I can definitely pray if my lord is satisfied prima facie to stay that notice, molding that relief. It ends and cut shorts litigation. I can always pray that. And it was my prayer in the court in the main relief, seeking not to invoke and, my lord, go on with that notice.
Very
My lord, and my lord knows the lord, I am not multiply. In mandatory injunction, strongest of the prima facie case, I can have a relief at the very threshold.
Nandan Pictures.
Nandan Pictures, my lord, I did not cite.
Indian Cables.
85 India Cables, all of them.
Chalo.
My lord, my lord is keeping it on.
When, Mr. Dasgupta?
Yes, tomorrow morning.
Tomorrow.
আবার চলবে
লিখে নিন।
আমি বেশিক্ষণ নেব না অত
Or
আইন
Mr.
জানি না
Chatterjee, learned কি সই করতে দিয়েছিলেন? ঠিক আছে
I'm for the opposite parties, number 1, 2, 3.
Well, I'm the defendant judgment debtor petitioner. Well, this is suit for declaration of title confirmation of possession. Well, directed against an order. Well, where the learned judge, well, appointing a advocate commissioner for identification of degreed property on the ground of shortage of survey pass commissioner. Well, your lordship, kindly sit down. Well, I'm very short, my lord. I'm point. The suit was degreed. Your lordship, kindly sit down. Now, my lord, the plaintiff opposite party put the degree into execution. I made an application under order of 21, rule 97. Your lordship, kindly see the page 42. Page 42 application. My
Yes,
application.
what is the problem? Is survey pass commissioner is appointed?
I don't lordship, I have no objection.
Yes, I have no objection. That is my only point.
Yesterday I have
But
raised this
26
point.
rule
I have no
9.
objection.
কোথায় গেল? নিয়ে This revisional
But I'm for the petition.
Lordship, I want the plaintiff opposite part.
The affidavit of service, my lord. Pursuant to my lord's last order, my lord, I have served the copy of the revisional application. Here, my lord, the issue, my lord, your lordship, while my lord passing the interim order, has recorded, my lord, the detail, the reason, my lord, behind the passing of the interim order. My lord, here, my lord, I am the defendant in a suit where the plaintiff, by virtue of appointment of an advocate commissioner, the evidence of plaintiffs was being recorded. Now, I applied for also, my lord, recording of my evidence by appointing advocate commissioner. That was allowed. The initial day when the learned advocate commissioner conducted, my lord, the proceeding, there is two things. First, the minutes of that day that is being recorded in a separate sheet, and the, my lord, deposition sheet is being prepared, wherein, my lord, it will appear that this evidence in chief is being, my lord, tendered. Some recording of evidence is being recorded in a deposition sheet where the parties have made signature. I am aggrieved with regard to the second day of, effective second day rather, of the conducting, my lord, the inspection process, wherein only a minutes is being recorded, which, my lord, acknowledge that many, my lord, rent receipt is being tendered on that day. But on that day, no separate, my lord, deposition sheet is being prepared, not even handed over. No signature of mine is being recorded over there, which prompted me to file an application before the learned trial judge for the purpose of, my lord, removal, or rather, my lord, substituting a fresh advocate commission. That was sum and substance of my application. Since my advocate on record before the trial court has made that certain, my lord, thing on record, being an officer of the court, my lord, he is assisting the court. Certainly, my lord, the court asked for a clarification from him. When the clarification was asked for, then everything is being provided, which, my lord, I have already narrated that yes, in the first day it is being acknowledged that yes, a separate sheet of deposition is there, but on the second day only the minutes is there, but no deposition sheet is being prepared. But the minutes records that yes, evidences was tendered, many rent receipts, rather the bulk of rent receipt is being, my lord, tendered as an evidence. But, my lord, the learned trial judge, by virtue of the order impugned,
commissioner not a single document is taken to the deposition.
But the learned trial judge, my lord, if your lordship takes up the impugned order, my lord, only, my lord, one portion, my lord, I will read second page of that last paragraph. Having heard both sides, has your lordship second page of the order impugned?
Yes.
Having heard both sides and considering the documents regarding proceeding of commission work, it is found that the application for removal of learned advocate commissioner has been filed on 6th of January 2026 in respect of the alleged incident happened on 18th of November 2025 and 19th of December 2025. There is no explanation regarding the delay of filing this application for removal of the learned advocate commissioner. Moreover, from the submission of the learned advocate, I'm not naming my advocate on record, it is found that in her own statement that she herself had signed the endorsement scheme before the learned commissioner had put the next date of adjournment application. This act of casualness is not expected from a learned advocate. Henceforth, she is requested that she would perform her duty with due care and caution. Therefore, this court finds lack of satisfactory ground for removal of learned advocate commissioner as prayed for. Lord, I may say, Lord, the clinching, the hinge issue that was not addressed by the learned trial judge. Rather, my lord, I am aggrieved that I tendered something, my lord, I argued before your lordship on the last occasion that even if the learned advocate commissioner is of the opinion that no, my tendering of those documents is not proper, then also I have certain avenue for espousing that cause. But if, my lord, those rent receipts are very important deciding this eviction suit, because there is a ground of default also. So if that is being so if I am not, my lord, given an opportunity, what is the fate of tendering those documents? My lord, kindly takes up, my lord, that minutes, because 11th, my lord, kindly takes up, my lord, the page 35.
And whose evidence is being taken on commission?
Defendants.
You are the tenant.
I am the tenant. Lord, page 35, this is the only minutes prepared.
This is the first day's minutes.
This is the second day, because I will show before your lordship page 33 and 34, your lordship kindly takes up first. The first day.
33.
33, my lord, would get, my lord, this is the minutes, which records that the chief is being tendered. The next page, page 34, is the deposition sheet, wherein your lordship will get, my lord, the answer and the question itineraries signed by my lord advocate on record as well as the lord my client. But kindly takes up transfer the page to page 35, which is only a
It says
minute.
plethora of documents.
Yes.
It does not identify what documents,
What
is the
document,
number.
what is the question, how I have
many
tendered,
documents?
whether those have been marked exhibits. So this is a technical flaw, my lord, which I, and I must be candid, on the last occasion your lordship asked me, Mr. Mukherjee, whether you really want to change. Yes, Lord, I also considered to that.
But he can correct the process.
Just before answering this, just Lordship, kindly come to print page 15.
15.
Plenty, my client is 90 years old. Husband died. And Lordship, kindly see the address of the 88A Raspberry Avenue. Area is 3,000 square feet. Rent, Lordship, kindly come. Paragraph 3. Last line. Paragraph 3, last line. 5,200. Have your Lordship got it? This is the rent. And Lordship, kindly come. Paragraph 4. Original tenant was Sujit Mukherjee, died on 9th April 2007. And in that paragraph, Lordship, kindly see her wife is died on 9th February 2017. Now the occupier is a test passer. He is her married daughter. My case, Lordship, kindly paragraph 7, Lordship, kindly see, it is a test passer 2G. And Lordship, kindly see, thereafter, Lordship, kindly see, they have asked for the advocate commissioner, that has been allowed on Lordship, kindly see the order dated 30th July 2025, page 29, Lordship, kindly see. 29, and Lordship, relevant portion is the page 30. Commission will be late C. Prakash Thakur has been appointed, Lordship, page 30, the relevant portion. Sri late Prakash Thakur, a practicing advocate, Alipur, associate such and such, without any objection, that has been ordered, has been allowed, and commission work within should be completed within 1 month. From Lordship, kindly see 30th July 2025 order have been passed. The commission work should be completed within 1 month. Thereafter, they took 5 times adjournment. They took 5 times adjournment. Only 2 times, I think, commission work has been heard. 5 times they have took adjournment. Lordship, this is the delay proceedings. My client is 90 years old, and Lordship, they have filed an application for removal. Lordship, kindly come the page 37.
Yes.
Page 37. Paragraph 4. Only 2 allegations. Paragraph 4.
No, I will not remove. I have indicated it on the first
Then I
occasion
shall
only. I will only say that the correct procedure should be adopted in recording evidence. That's all.
And Lordship, on pair, Lordship, subject to my learned friend also. Lordship's kind, their allegation is.
I'll fix it. Mr.
Fix the
Mukherjee, finish it fast.
Yes.
I'll fix it within.
Just Lordship, kindly pending this matter. Lordship fixed 5 or 6 days, because their intention is that they have not given opportunity more time like that.
No, there will be.
That's why Lordship by
There
fixed
will be
date.
an order to complete the examination of the witness within a specific time. And if within that time it is not completed because of the fault of the the witness,
Correct.
then in that case the
Lordship,
evidence
kindly
will be
pending
closed.
this matter, Lordship, kindly pending this matter, and that the matter will be. Otherwise, Lordship, this.
I'm making it clear that I'll say that the witness, whoever it is, it has to be concluded within the time which I will just now indicate. If within that time, for some reason, it is not being concluded and the reason is attributable to the witness, then in that case, it will stand closed. For example, if the advocate commissioner falls ill and he does not go there, then in that case, he cannot be punished. But if he goes there and he is not available for some reason, then in that case,
Lordship, today I have talked to the advocate commission. Up to 18th this month, he will be partner like that. After 18th, he will available at any day. Lordship fixed one by date.
Two things, my lord. 18th November, the minutes, but without, my lord, the deposition sheet, that your lordship kindly makes it
Everything will
clear.
be
That
according
is,
to law.
that is,
Say that he will
Everything will be
revisit
according to
that.
law.
yes,
He
yes,
will-
yes.
he will
I am
revisit
only on that.
Those evidences will be retendered
Yes.
so that it is
Yes,
the
yes.
process
Clear,
is
yes.
complete, and upon completion of the process, recording it in accordance with law, he will conclude the process within a specific time frame. If within that time frame he is not able to conclude by reason of anything which is attributable to the witness, that is the defendant or the defendant's witnesses, then in that case the defendant's witness will be closed. Evidence will be closed.
And my lord, the rest one thing, my lord, kindly my advocate on records, my lord, conduct is being recorded by the learned trial. Just kindly, my lord.
From the application and the affidavit filed, the bar is different.
No, my lord.
Separate allegation has come. That has been recorded in your lordship. That I have seen also.
This revisional application is directed against an order dated February 10, 2026, passed by
This is, Your Honor, I have come for a local commission because the trial court has rejected my prayer. Means I have given 1,744 square feet lease to the respondent for 99 years. But from 2005, the respondent has stopped paying me the rent, which was the only consideration. And moreover, I found there is a huge illegal, and they have extended the leasehold property, which is about
Where is
10,000 now.
your application for appointment of advocate commissioner or survey past commissioner? Sorry. The application is not annexed.
No, Your Honor, the application is not annexed.
You have a copy?
No, at present I don't have, because I haven't served the copy also.
Yes, but that is required for me to see as to whether the case has been made out. You bring a copy of the application. I'm making it not today.
Okay, okay.
Not today. Tomorrow you will be able to bring it.
No. Hey, next week, Your Honor, because tomorrow I have.
लिखे नहीं.
For 9, I am the plaintiff petitioner, my lord. But before starting the 9, my lord, I found that the opposite party also filed an application under Article 227 regarding challenging the previous order, which I challenged, my lord. My prayer is that to kindly heard both the application analogously. And it is running in the monthly list, my lord.
What is the item?
Item number, it is 776 of the combined monthly list dated
776 এর সঙ্গে রেখে দিন তো. Why? What is in challenge?
They are challenging an order that was that rejecting their application for condolation of delay in depositing the area rents.
You have served a copy of this?
Yes, I served. In my application, I served. The affidavit is ready, but it is not affirmed, my lord. But I undertake to affirm this.
Affirm it and file it. I'm passing an order. Should I pass an order? You'll be able to do it in course of this day.
This day.
Serve it, otherwise file it, otherwise not sign the order. File it in course of the day.
Within 5 minutes.
এটা দিয়ে দিন, ওনাকে দিয়ে দিন. I'm dictating the order, but you file it. লিখে নিন দিদি. The order will be signed only after you furnish it. Otherwise, I will recall it. It will again appear.
No, absolutely. I undertake.
List this matter along with CO. What is the number?
Your number is 578 of 2026.
578. List this matter along with CO 578 of 2026. Yes, yes.
This is with regards to a preemption and followed by a misappeal. I have come against the direction of learned additional district judge Uttar Dinajpur. If my lord comes to page number 20, that will help me explain the matter to my lord.
Page
20.
Page 20.
There is a map, my lord.
Yes.
Yes, my lord. Okay. My lord, this entire map is 80 decimals of land. This is owned by two persons, Shish Mohammed and Isha Mohammed, 40 decimals each. Now, my lord, the dates are very important. In the year 1999, Isha Mohammed sold 17 decimals of land to Rejabul Haq. And Rejabul Haq subsequently in the year 2003 sold these 17 decimals of land to the defendant Nasiruddin, the extreme left portion of the plot. After that, the remaining 40 decimal, which was owned by Shish Mohammed sold that 40 decimal of land to Muhammad Ali Jinnah, the extreme right side of the plot. The dispute is with regards to the middle plot. The middle plot, my lord, is 20. Huh?
Farak Hussain.
Yes, my lord. It was sold in the year 1997, 23 decimal to Altanur Khatun. Now, Altanur Khatun was the owner of that middle portion of the plot. On 4th July 2012, Altanur Khatun sold these 15 decimals of land to the petitioner. The petitioner is deceased, followed by the substituted person, to Mobarak Hossain. On 31st July 2012, after that, Altanur Khatun sold this plot to Nasiruddin, the person owning the extreme left plot. After purchase of the plot, he had filed an application for preemption. Now, my lord, if my lord has understood the portion, my lord, the matter was moved before the learned junior division, civil judge junior division. I have annexed in annexure B, page 21. Learned civil judge junior division had accepted this very portion, that they are all stranger purchaser, and they have accepted that he had already purchased the plot and they don't share common boundaries as on date of his purchaser, and thereby has dismissed the application. This was moved before learned additional district judge Uttar Dinajpur. Now, my lord, if my lord takes up the order of learned additional district judge Uttar Dinajpur.
Yes.
Page number 5 of 10 of the order, my lord.
5.
Decision and findings of the court. My lord, I will keep on reading. The bone of dispute as apparent from the crux of submission of the parties in the present misappeal, it appears that admittedly entire 80 decimals of the suit land belongs to Shish Mohammed. My lord, first error. Shish Mohammed is not the owner of 80 decimals. Shish Mohammed, Isha Mohammed. They are 40 decimals each. They have owned from their he had transferred 40 decimals land in favor of Muhammad Ali Jinnah. Altanur Khatin got 23 decimals of land. The appellant petitioner purchased the remaining 17 decimals. The initiation of the dispute was transfer of 15 decimals of land from the suit land in favor of the respondent OP by registered deed of sale for consideration money of 5 lakhs. My lord, now comes to paragraph number 12. During the pendency of the preemption application, the appellant petitioner had purchased the remaining 8 decimals of the land. My lord, error number.
Purchased this prior to the filing of the.
My lord, he had purchased on 31st of July and he had filed the matter on 7th of August. My lord, e-courts. Huh? Yeah, I have given the e-courts. E-courts document.
Long back. I satisfy your.
No, no, I am talking about this particular portion. He had purchased the previous plot long back. He had purchased it, my lord, in the year 1999. In the year 2003 from Rejabul Haq.
No, but if it is on 7th of August 2012, then
And he had purchased it on 31st of July 2012, the 8 decimals of the property, my lord. If my lord goes back to the map.
Yes, so this 31st of July 2012 is prior to 7th.
Yes, my lord, but the plot in which he is preempting, I had purchased it on 4th July 2012. I had purchased on 4th July 2012. After that, he had purchased that pocket of land. After that, he had filed a preemption application. He might have purchased the extreme right portion of the land long back. But the boundary is mine. I had purchased on 4th July.
Show me from the map because the names are given. Show me now, tell me who is the opposite party so that I can mark it here.
My lord, the map in page number 20 once again.
Yes. First, you have earmarked as Nasiruddin.
Nasiruddin. Nasiruddin is the 17 decimal, which he.
Who is the petitioner here?
Petitioner is Mubarak Hussain. I mean, descendants of Mubarak Hussain. He has expired.
Mubarak Hussain. Yes. So Mubarak Hussain purchased in 1997.
No, my lord. I'll just say it. In 1997, Altanur Bibi purchased the entire boat, 8 decimal plus 15 decimal. This entire block was purchased in 1997.
8 and 15, which a portion of Nasiruddin and Mubarak Hussain.
Yes, it was jointly purchased. By Altanur Khatun. Altanur Khatun.
Altanur Khatun. Very well.
Okay, my lord. Yes. The 17 decimal was previously purchased in the year 2003 by Nasiruddin.
Very well.
Okay.
So Altanur Khatun became a co-sharer. I mean, had a boundary with Nasiruddin.
Yes, my lord.
Right.
Now, Altanur Khatun also had a boundary with Muhammad Ali Jinnah.
Yes,
my lord.
Right.
Now, this 15 decimal from the side of Muhammad Ali Jinnah was sold to me on 4th of July 2012.
To you means?
To Mubarak Hussain, the petitioner.
No. After Altanur Khatun, Mubarak Hussain came when?
2012.
2012.
4th July 2012.
Mubarak Hussain purchased 15 decimal out of the 23 decimal.
Entire 23 decimal on 4th July 2012.
And the balance 8 decimals were purchased by
on 31st of July 2012 after my purchase.
Very well.
And on August, the preemption application was filed.
August preemption application was filed in respect of which plot?
In respect of this in this entire plot, 15 decimals of plot.
15 decimal?
The 15 decimal of my Mubarak Hussain plot. Learned Civil Judge Junior Division had rightly held they don't share boundary. They are
right.
May I?
Yes.
My lord. First of all, my lord, I am objecting rating the map, my lord. It is by the creating by the petitioners. Because there is the case is that there is no demarcation. The entire 80 decimals of land, it is not demarcated by either of the partition, deed, or court of partition. It is joint. And in the village, my lord, there is no partition in everywhere. It is taken by the landed court, my lord, the district court below. That
he has not gone on the basis of boundaries then.
No, there is no boundary. Entire 80 decimal land is acquired by the. It is never by the boundary or never by suit of partition.
What is the reason on the basis of which the learned appellate court upset the decree of the trial court?
Yes, my lord. Regarding my lord, regarding paragraph from onwards, paragraph 13, and by giving judgment from paragraph 16, 17, he says that the main dispute, my lord, there is no demarcation. The petitioner became the
The opposite party became the co-owner in the year 2003.
You have instituted an execution case.
Execution case, no, till date, no, just this is the order passed by the judge.
This is just the order passed, my
Passed by the no execution. He will
but
file.
This
they are
has
trying
be,
to.
This has to be heard before the vacation. May not be possible.
Well, the order passed by
because
the
it
court
needs
will
to be executed. Unless an execution is filed, I will fix it immediately after reopening.
My lord, if my lord grants a stay in the meanwhile, my lord.
Say I am objecting, my lord.
Execution has not been levied as yet. I am not in. I'll make it clear that you can make a prayer for stay.
My lord, some protection in the meantime, if my lord.
Well, I am
Let him file
objecting.
execution
File the
first. He has
caveat,
not
my
yet
lord.
filed execution.
My lord.
It will remain on execution.
If we are filing the execution,
My
we
lord
will
mentions it
execute.
in the matter.
This revisional application is directed again.
তুই ছিলি না বলে ওটা এই যে পিটিশন এটা মানে উঠতে শুভনি
Well, I am for the only opposite party number 1. I am not 2.
My lord, there was a caveat, that is why.
No, opposite party number 1 file a caveat. Yes. No. Only I.
No, the other one is pro forma.
Yes.
My lord, at least not to disturb me much. Any date mentioned, my lord? Much.
Deeply.
Much. I have.
In the two sides, my lord, we are there in the property. How the disturbance will go?
Let that be hard, my lord.
Already we are. Yes, my lord, we are already in there. Why are you disturbing? My lord.
17 June.
Deeply obliged.
Much.
My lord, I am for the petitioner, my lord. My lord, this is my application for expeditious disposal of a partition suit pending before the learned court at Shialda. Now, your lordship's pleasure was to
expeditious disposal, but there is a lordship application, civil
Which is
divisional
why your
application.
lordship had directed to serve.
Both be tagged together, lordship, because
No,
the-
cannot be. That is an
because
civil
lordship,
division
in the-
application.
in the civil divisional application, we have challenged the rejection of the amendment application. By way of amendment, lordship, we prayed for lordship insertion of some counter claim. Now, if the application is lordship allowed, entire scenario will be changed. And lordship, another thing, lordship, if you lordship find from the record is misplaced by the learned trial court.
My lord, it is for
Yes.
them to take steps. Your lordship will kindly see the order that was passed. My lord, my lord will also kindly appreciate. Yeah. My lord, interim application was disposed of, amendment rejected. They come up before this honorable court, file an application under,
is pending.
my lord, Article 227.
Now, lordship,
They have not taken any steps to extend this
they are
stay.
taking steps. The difficulty
My lord, not for 6 years.
And
My lord, this is then my lord, should I come back in the next?
My matter will take only 4 to 5 minutes only.
Then my lord. My lord, they were supposed to show, my lord, they are not notified under section 45(1).
Yes, this is the copies of the registered NBFCs with RBI. আমি আপনাকে drop করে দিচ্ছি। So far, lead petitioner was concerned, it was a company registered with RBI. So far, petitioner is concerned,
My lord,
in any case, they have preferred essay.
My lord, only thing, my lord, that I would want to indicate, my lord, if your lordship takes a look at the notification once, my lord. And my lord, before that, my lord, once the order, my lord, passed by the coordinate bench, my lord, it has not been determined, my lord, whether, my lord, the NBFC is notified under the under section 4. And my lord, it has been referred, my lord. And in any event, my lord, after the division bench's order, my lord, I've seen, my lord.
Page 2 of this order, 30th January 2026 order.
And my lord, after the
Page 2 of
my lord,
30th.
I am
Please stop talking and listen to the quote first. Come to page 2.
My lord, I am on the page 2.
Read the second line.
It is also made clear that even if all the housing finance corporations can be classified as NBFC, they do not fall within the mischief of notifications aforesaid.
Then,
my lord, after this, my lord, the
say that it
division
has not
bench's
been
order
decided.
comes in.
It has been decided then.
My lord, after this, my lord, division bench's order comes in.
After this division bench says that this order was challenged in appeal.
No,
No,
the first order.
the order
This point did not fall for consideration before
that
the
is
division
that
bench.
is falling before your lordship for consideration.
So falling before me for consideration, already there is an order. Why will I differ from it?
My lord, kindly consider, my lord, the notification once before that. My lord, once.
Say that. Don't say that the order doesn't say so. The order says so. You
my
say
lord,
that the notification. Now show me the
kindly
notification.
comes.
Show me the notification.
My lord, at page 18 of my application, my lord.
18.
18.
18.
My lord.
Yes.
And a sixth line from bottom, my lord. The central government hereby specifies that such non-banking financial companies as defined in clause F of section 45I of the Reserve Bank of India Act, having asset worth rupees 100 crore and above, which shall be entitled for enforcement of security interest in security dates of rupees 20 lakhs and above. My lord, this notification does not mention or restrict the applicability of the notification in respect of the NBFCs notified under section 45(1),
That is the
45I.
notification. It says, specifies that non-banking financial companies
Within
as
the
defined.
meaning of section 45F.
Yes.
My lord, they are claiming themselves are NBFC within the meaning of section 45IF. My lord, I have shown your lordship, my lord, from their application. My lord, kindly seize, my lord, their application. My lord, in the cost title, my lord, so as to claim, so as to be enable themselves.
What does section 45I of Reserve Bank of India
My
Act
lord,
say?
I'll show.
I.
You have RBI?
Yes, madam. I'm handing it. I.
My lord, this is. If I may place, my lord.
Yes, it means that only. Please read F3.
My lord, if
3.
my lord, if P is not just probably, my lord. If
FI, FII, then FIII, F3. Such other non-banking institution or class of institutions as the bank may. So the bank's notification must contain their name.
My lord,
This notification that you are showing is the ministry's notification.
Yes.
Right.
Yes.
Now the section says that such notifications whose names the bank will specify. How will the bank specify the name? By a notification.
Bank specifies, my lord, the notification under clause F having what asset worth more than 100 crores. Only quality, my lord, qualification that is there is more asset worth 100 crores. My lord, and my lord, one more thing, my lord, the difference between the NBFCs notified under section 45I and that which are not, my lord, is that the which are notified under the section 45I has to comply with section 45IA, and which are not, my lord, are exempted from compliance of section 45IA, IB, IC. My lord, that does not mean, my lord, they are not NBFCs anymore. They are NBFCs, my lord. They are claiming themselves to be NBFCs so as to enable themselves to claim financial institution under section 2N of the Services Act, my lord. And at the same time, my lord, they are seeking exceptions of the notification which are meant for the NBFCs, my lord.
Very well.
My lord, kindly seize, my lord, their application, they are the cost title, my lord. They are
back
saying,
tomorrow then. Come back tomorrow. Today we hardly have any time. I have a fixed matter at 2. দিদি এটা চলে গেল একটা RBI Act আনিয়ে নেবে না
Before your lordship's rising, may I have your lordship's
Just a minute, I have not yet completed. নিয়ে নিন third
interim order is appearing to this list, whether if your lordship take up at
If you come, I'll take it up at 3:30.
3:30. I deeply object.
Or maybe at 3 after there is a fixed matter at 2. I don't know what time it will take some time.
The interim order is expiring today only. We will come back at 3:30, lordship.
My lord,
Under
my lord,
compelling.
my lord, I want to mention an order passed on 4th May. I was appearing in person as cancer patient.
Yes, yes.
Order is stated that from next date, 6 months from next date. Next date is of October 2026. The next date is after 6 months. Kindly consider that. Next month, next date is October 26. I am a cancer patient.
I directed the suit to be concluded within 8 months.
No, but this is next date is 6 months. You have mentioned, my lord mentioned from next date, 6 months from next date. And next date is from October 5th. Already 6 months away. Item number 84 monthly list.
Yes, but that was passed in. Why didn't you inform me then that it is on 6th October?
I cannot understand from date.
Then after the order is passed, I cannot change it anymore.
My lord, consider I am in person and in cancer patient.
That I understand. You make an application for modification, I will modify it.
Okay, thanks, my
lord. Under compelling.
You make an application for modification because after signing the order and after it is uploaded, I cannot change it. On that day,
Okay, I will. Okay, my lord.
On that day, if you had said, I would have.
তুমি senior, তুমি আগে বলবে।
Senior junior.
Okay, my lord.
তুমি senior, তুমি আগে বলবে।
Thank you. You file an application, formal application, 1-2 page application, I will change it.
Okay, my lord. Thanks.
আমার দুই senior আগে বলো।
My lord, I had item number 276 for extension. My lord, I have heard my lord would be taking up the matter at 3:30. My lord, Mr. Shawkar is there. He is consenting to this extension. If my lord kindly passes a one-liner order, my lord, now because
we'll do it at 3:30. You will not
do it. May get my lord occupied somewhere. No, that's the difficulty. My lord, item number 270.
Okay, let this be finished.
May I be permitted to deposit the affidavit of?
Yes. ওটা affidavit of service টা নিয়ে নিন। ওই একটা ম্যাটারে বাকি ছিল এনার।
I'm not getting. My lord, under compelling circumstances, I would not have mentioned. My lord, I have challenged my lord an order passed by the Land Arbitral Tribunal. Now, my lord, the matter has been fixed for further hearing, dismissing my application for termination of the mandate on my lord 9th Saturday for the whole day. Now, my lord, I had my lord uploaded the entire petition in soft copy on 4th. On 4th, my lord knows what was the situation. Entire 4th gone. Millard, nobody has come, nobody. Now on 5th Millard, it has been done. Now Millard, it was initially kept returnable on 6th before your lordship. Then Millard department requested my clerk that you keep it on 8th because 48 hours notice or something like that. Now Millard, the difficulty is that Millard, it has been done. Now Millard, they are insisting on date of 11th. Now Millard, 11th, my civil division becomes infructuous.
Why?
Because 9th the date has been fixed on Saturday.
Even if the
no arbitral given, it has been.
If the arbitral mandate is, say, he continues with the arbitral proceedings, what will happen?
It's fixed on Saturday.
Very well, it will not be concluded on that day.
No, it will be. Because in order it has been written, the entire day has been fixed 2 sessions for finishing it. Now, Millard, if it is kept on, I was humbly beseeching to kindly keep it on 8th, 1 day prior, because we have 48 hours still time.
8th, I'll not be taking up civil revision matters. 8th, I will not be taking up civil revision matters because assigned matters I have not touched. So I have fixed.
Then Millard, I have to ask.
It has to be on 11 only.
11 difficulties, and then Millard, entire exercise will be. It's not my fault, Millard.
What will happen? What will happen?
Because Millard,
he will pass an award on 10th.
Yes.
9th. No.
Because I can show the order.
And in any case, if he passes about section 34 is there, what is the problem? You are not remediless.
No, I am not.
Then, that's Gupta now. No, not don't.
No, not that. That's not my fault, Millard.
I understand. It's not their fault also. Maybe something is wrong there with the server. Every time the court cannot intervene like this.
No, I'm not seeking intervention. Kindly, Millard, allow me to come back any day before 10th, the 9th.
When do you will come back tomorrow? You will come back day after tomorrow. How will I say this? You haven't
kindly tomorrow, Millard. Any time, Millard. But any in the list, Millard.
File it, give a date
No,
on
they
it,
are not
whatever date.
taking, because the returnable date has to be given as 11, then they will not take the hard copy otherwise. So difficulty is not on my part. Is there some technical thing?
Nothing will happen if even if it comes
they
at
have,
11.
no, they have
There'll be
indicated
no
that.
problem.
No, they have indicated that.
No, Mr. Dasgupta, no.
I'm saying
Mr. Dasgupta, I will not. Mr.
For a second,
Millard, please don't mention now.
2 seconds, Millard, 2 seconds, Millard, 2 seconds. Well, they have indicated that if Millard an
Mr.
endorsement can be made.
Dasgupta, I will not entertain this. This is every time I cannot. Chalo, Mr. Chaudhary.
My petition becomes infractuous.
Nothing will happen. It's not that. It will become infractuous. Chalo, yes, Mr.
My lord, this is that matter.
Millard, may I say, let it be listed on 8, may not take, so that I can show to the arbitral tribunal the matter is listed. They are on KVA. So let it be listed so that I can show the list and seek an adjournment.
Listed, to be listed on it.
It to backsheet লিখে দিতে হবে, listing for filing and it.
File it today, it will be listed on
8th, yes.
Serve the caveator.
Already served, done.
Yes, Mr. Chaudhary.
My lord, this lordship would recall the short point involved is, my lord, whether the right of a mortgager for redemption, when does it evaporate or merge vis-a-vis the rights of a auction purchaser or rights of a purchaser? I won't say auction purchaser, rights of a purchaser. Now, lordship will take the list of dates which I had handed up to your lordship. List of relevant dates, because our point is very short.
Yes.
But since, my lord, we have, last time I addressed your lordship, there has been a time lag. Just allow me 5 minutes, my lord, I'll quickly place the dates. The lordship will find the facilities were sanctioned in 2006. 2016 is, my lord, when a section 19 application is filed. That is OA 55 of 2016. So this is not under the SURFACE. This is under the Recovery of Debts Due to Bank and Financial Institutions Act 93. Then, my lord, 25th is the decree for 1,60,91,000 and odd, with penalty light interest at the rate of 10.25% per annum from the date of filing of the OA till full and final realization. So date of filing, if lordship sees 2016, decree date 2019, effectively 3 years. Execution proceedings filed before recovery officer, RP 124 of 2019. Then 2nd March 2022, order passed by recovery officer directing receiver to take physical possession of mortgage property. Valuation reports, 3rd September 2024. But I am not troubling your lordship with the valuation issue. In the event we are successful, it remains alive over there, then that's an issue. I have to satisfy your lordship on a preliminary and primary point on the right of the mortgager. When does, up to what time, the right of redemption of the mortgager survives? Then 13 November, order passed by recovery officer fixing terms of sale. Sale notice issued. 24th November, initially an order of status quo is passed. Then 27 December 2024, letter issued by petitioners to bank proposing revised OTS for sum of 3,69,47,000. Upfront amount of 33 lakhs was paid by the petitioner. I want to kindly marks this date. That is, 27 December 2024. Because, my lord, when the first tranche of payment comes, the sale process is yet to be initiated. Then 2025 interim application so-and-so filed by petitioner. 8 January 25, DRT passes an order dismissing interim application and fixing a date for e-auction. 8 January 25, bid amount deposited by the auction purchaser for the sum of 36,94,700. 10 January 25, order passed by recovery officer directing sale of the mortgage property in favor of OP number 2 Well, Lordship will mark this date also, 10 January 2025. This is only the order passed. Now, well, this 10 January 25 was the subject matter of challenge before the presiding officer in the debt recovery tribunal, where, my lord, the concept of deposit and all that issue. I'll come to that. Then 13 January, balance amount of 25% for sale of mortgage property being sum of 56,34,000 was paid by the auction purchaser. So, my lord, initially one sum, then balance 25%. Earnest money and 25%. This is what has transpired so far. Then 15 January 25, letter from bank to the petitioner returning the upfront amount of 33 lakhs. 24th January 25, petitioner challenged the order of 8 January and 10 January in an appeal filed under section 30, being appeal number so and so. Petitioner deposited the sum of 1,85,70 towards 50% of decretal dues. Kindly marks this date. So even before the auction purchaser could deposit 75% of the amount, I had preferred an appeal. I had deposited 50%. Earlier, I had shown my conduct
33 lakh.
33 lakh, which was returned.
So 1.85 plus 33.
33 was returned. 33 was returned, but my lord, I take it, well, let us say 1.85 over here. I am showing the conduct. I had given 33, I have come up with 1.85. Because the decretal amount with interest comes to 3.69. 1 crore and odd with that.
Decretal sum is less than
I know that.
69
With interest, it comes to, my lord, 3.69. Okay. But I stand corrected, my lord. 3.69 was my offer. Decretal sum is much less than that. I'll give your lordship the exact figure. Well, it kindly comes to 6th February. In fact, this entry will make it clear. 6th February 2025. Order passed by DRT in appeal number 1, refusing interim protection or relief to the petitioner. 6th February 2025. Petitioner paid a sum of 1,41 lakh to bank through RTGS. The amount covered the entire decretal dues. Well, I stand corrected. 3,12,06071. As on that date, considering the previous tender of 1,85,00,000, the petitioners made payment of an additional sum of 15,19,743. Because, well, this amount was deposited pursuant to a calculation which was furnished by the bank officer, saying that, all right, you have deposited that amount, you deposit a further this, then we will consider.
And this 1.41 crore was paid to the bank through RTGS for what purpose?
Well, this is that time, my lord, OTS and all that, that settlement and all that, my lord, when
by way of an upfront.
No, this was done, my lord, pursuant to, because the bank's officer calculated and told us the amount, it was paid to the bank. They will consider our case.
So this 1.4, because this 1.85, the earlier deposit, this appears to be a deposit under section 30 because of the statutory.
Correct. That's
and the other deposit of 1.
This is, my lord, voluntary to show whether, my lord, it was under OTS or talks of settlement. It was for the purpose of satisfaction of the decretal dues.
was deposited in the loan account.
And this was deposited in the loan account itself pursuant to the instructions of the bank officer.
Statement also.
And it is reflected in the statement. There is no dispute.
No instruction. No instruction was. They can directly deposit the loan account, lordship, no, my lord. So there is no instruction required.
Now let us say, my lord, the money is there. Now, my lord, bank cannot take a stand that I will receive, I have got the money, but I will not take it because I will go ahead with my right of sale. That is, my lord, the short point. And this is the point, my lord, I want to destroy this obstinacy of the bank, because, my lord, I will try to show that right of redemption of a mortgager is there till the last day, my lord, the sale deed is executed. And this is, my lord, the misconception which I am trying to, my lord, dispel. So, my lord, kindly makes a note, as on 6th February 2025, and, my lord, the bank cannot dispute that, my lord, I have been out of pocket and I have given either to the bank and I have given in deposit in court, and I'll rely on a judgment also because, my lord, it fell from your lordship, whether a deposit made in court can be said to be a deposit to the bank. Because, my lord, now it is very clear, if the judgment debtor or the mortgager gives consent in any deposit to the court, to the extent of that this money will be appropriated so far as that is concerned, that is enough. Because they cannot, my lord, insist, prolong the matter and say, I am creating an equity in favor of auction purchaser. Once I have put in the money, my lord, the equity of auction purchaser comes to an end. And, my lord, admitted position as on 6th February 2025, the sale was not done. 18th February 2025, this amount was received by the bank when the sale was inchoate. Total amount lying to the credit of execution proceeding being RP 124 before the sale certificate was issued is 3,27,25,814 with an excess amount of 15 lakhs and odd. Right of redemption should therefore not be denied to the petitioner. Letter from the petitioner to the bank towards payment of certificate amount comprising amount of 1 crore 85 and 1 crore 41 and requesting for a no due certificate towards completion of payment of dues. That's on 18th of February. Appeal filed by the petitioner before DRAT Kolkata challenging the order dated 24th February, refusing to grant interim relief. 10th March 2025, during pendency of challenge, sale certificate has been issued in favor of OP2 for a sum of 3 crores 7316. This date is very important. Kindly marks the date. So sale certificate is issued almost nearly a month after I have shown, or rather put in the entire month. But in fact, we have got the entirety of the DRT records because, my lord, Lordship had directed that if necessary, Lordship can have a look at that. And 18th March 2026, impugned judgment of DRAT Kolkata confirming the order of DRT Kolkata dated 6th February. My lord, 6th February, Lordship will go back to the list of date was the order where, my lord, interim orders were refused. Order passed by DRT Kolkata refusing interim protection. So, my lord, this is where we stand. So, my lord, factually, two positions are admitted. Number one, that I, being the judgment debtor mortgager, I have exercised my right of redemption prior to the sale certificate even being issued. Prior to the sale certificate being issued. Number two, the entire money and in fact some excess, 15 lakhs in excess, is lying either in the hands of the creditor, whether he voluntarily consents to accept it or not, it doesn't really matter. And to the credit of the appeal, where, my lord, I succeed, I don't succeed, because my consent is to be there and the consent is evident from the conduct. I have said, because I wrote a letter saying that, look, 18th February letter, I have.
So it is as good as a payment to the mortgagor.
Correct. Tender. My lord, the expression in section 60 is tender. 60 of time. And, my lord, my consent, the 18th
to the mortgagor.
18th February letter is also recording the consent. So, my lord, in this factual position, I had first relied before your lordship, my lord, on the judgment of Matthew Verghese. Lordship will just take up that. I'll quickly refresh, my lord. There are you.
Yes, yes.
এটা আছে দেখুন তো জজ সাহেবের মার্ক থাকবে
আছে আছে I have it. Paragraph 36.
Yes, Malik. In fact, my lord, Narandas has also been considered.
Yes. That is the parent judgment of redemption.
But if I may read from paragraph 37.
Yes.
Mr. Sham Diwan, learned senior counsel, relied upon the decision in Narandas Karsandas, in which the right of a mortgager, as prescribed under section 60 of the TP Act, has been spelled out. Well, the reason, well, at the cost of repetition, I want to repeat, this is not a sale under surface.
Yes, yes. The right of the borrower.
Correct. It is
rather the mortgager. It continues.
It continues. The general law applies. Special statute does not apply.
The Surface Act, it curtails the right.
Curtails the right, yes, because of the special statute. Under section 60 of the TP Act, at any time after the principal money fell due, there is a right in the mortgagor on payment or tender at a proper time and place of the mortgage money to require a mortgagee to restore the property to the mortgagor with all rights prescribed as it stood prior to the mortgage. Under the proviso, the only impediment would be that if such a right of a mortgagor stood extinguished by the act of the parties or by the decree of a court. Certain other conditions are also stipulated in the said provision for mortgagor to seek for redemption of the mortgage property. Dealing with the said provisions, this court held as under in para 34 and 35. May I read this paragraph because this is the one which would have an important bearing on this case. The right of redemption which is embodied in section 60 of the Transfer of Property Act is available to the mortgagor unless it has been extinguished by the act of parties. The combined effect of section 54 of the Transfer of Property Act and section 17 of the Registration Act is that a contract for sale in respect of immovable property of the value of more than 100 rupees without registration cannot extinguish the equity of redemption. In India, it is only on execution of the conveyance and registration of transfer of the mortgagor's interest by registered instrument that the mortgagor's right of redemption will be extinguished. The conferment of power to sell without intervention of court in a mortgage deed by itself will not deprive the mortgagor of his right to redemption. The extinction of the right of redemption has to be subsequent to the deed conferring such power. The right of redemption is not extinguished at the expiry of the period. The equity of redemption is not extinguished by mere contract for sale. Now, my lord, para 35. The mortgagor's right to redeem will survive until there has been completion of sale by the mortgagee by a registered deed. In England, a sale of property takes place by agreement, but it is not so in our country. The power to sell shall not be exercised unless and until notice in writing requiring payment of principal money has been served on the mortgagor. Further, section 69(3) of the Transfer of Property Act shows that when a sale has been made in professed exercise of such a power, the title of the purchaser shall not be impeachable on the ground that no case had arisen to authorize the sale. Therefore, until the sale is complete by registration, the mortgagor does not lose right of redemption. My lord, here, for purpose of notice, you have my 18th February letter. The sale certificate was issued almost after a month after I had put in the money and I had expressly conveyed by my letter of 18th of February that I have deposited the money. More than that, it is treated. So, my lord, all these are now, my lord, para 38. On a reading of the above paragraphs, we are able to discern the ratio to the effect that mere conferment of power to sell without intervention of court in mortgage deed by itself will not deprive the mortgagor of his right to redemption, that the extinction of such right of redemption has to be subsequent to the deed conferring such power, that the right of redemption is not extinguished at the expiry of the period, equity of redemption is not extinguished by mere contract of sale, and the mortgagor's right to redeem will survive until there has been completion of sale by the mortgagee by a registered deed.
This is a repetition of what has.
This is a. So, my lord, this is so far as, my lord, I won't trouble. It's the same thing. I had shown it on the last day. And, my lord, the distinction, the Surface Act, and that has also been.
That doesn't fall.
That doesn't. That is not. Now, my lord, I want to cite a recent judgment of the Supreme Court, my lord, authored by Justice Dipankar Datta. This is with regard to SURFACE And my lord, even under the SURFACE provision, which is more stringent, this right of redemption, the equitable right has been put at a superior pedestal than that of the general law. My lord, this is my lord 2026 SCC online. Oh, copy the Lordship will, my lord, kindly first come to my lord paragraph 8. Eight. My lord, in fact, if I may read from my lord para 6, where my lord, what had transpired in High Court, that has been summarized. The High Court recorded, well, this was from DRT, then DRAT, then High Court, then Supreme. And from SURFACE, proceedings under SURFACE. The High Court recorded that although the auction was conducted on 4th September, a series of interim orders passed by DRT, DRAT, and High Court had at different stages interdicted confirmation of the sale. While such protection was subsequently modified, the High Court construed its order dated 15 December 2020 in CRP so-and-so as permitting confirmation of sale and receipt of balance of 75% of the bid amount, while restraining only further steps such as issuance of registration and sale certificate. On this interpretation, the High Court held that the secured creditor and the auction purchasers erred in deferring confirmation of sale until 13th March, resulting a delay of nearly 15 months. Holding that such a delay was contrary to Rule 9(4) of the 2002 rules and inconsistent with the principles enunciated by the court in Matthew Varghese versus Amrita Kumar, the High Court concluded that the sale stood vitiated by material irregularity. The finding of the DRAT that the confirmation of sale was stayed till disposal of appeal under Section 18 was held to be factually incorrect and unsustainable. The High Court further held that the borrower's right of redemption had not stood extinguished, notwithstanding issuance and registration of sale certificate, particularly as the borrowers had been contesting the proceeding at every stage and had paid the entire outstanding dues with interest during the pendency of the writ petition, emphasizing that the object of SURFACE Act is recovery of dues and not deprivation of property. Where the debt stands fully discharged, the court permitted redemption of the mortgage property by the borrower. So, my lord, up to High Court stage, it, my lord, followed the Matthew Varghese principle, and my lord, it upheld the borrower's right of redemption, against which the bank goes up to the Supreme Court. Now, my lord, para 9. Accordingly, the auctions and sale certificates were set aside. The secured creditor was directed to release the secured asset from the mortgage and return title deeds to the borrower, and the auction purchasers were held entitled only to refund of the entire sale consideration with interest at 12%. Then, my lord, two questions of laws were framed in para 10. The first one is whether an auction sale under SURFACE Act, once confirmed and followed by issuance and registration of a sale certificate, can be annulled by High Court in writ jurisdiction on equitable consideration. Whether borrower's right of redemption survives issuance and registration of sale certificate under SURFACE. So, my lord, this is one notch higher factually. And, my lord, straight away, Lordship will come to paragraph 16. 1.6. The resolution of the present list turns rudimentarily on chronology. When statutory timelines are invoked to justify divestment of property, the court must first ascertain with precision whether delay is attributable to the borrower or is the upshot of judicial intervention and procedural restraint. The record before us furnishes a clear answer. But I have gone to DRT, I have failed to get a stay, but my lord, good, bad, indifferent, the money is before the court. The secured creditor issued a demand notice under 13(2) of SURFACE calling upon the borrower, upon failure to do so, symbolic possession. Then para 18, sale notice under 8(6) was issued on 31st July. Date of e-auction was 4th of September. Auction was conducted as stated. Auction purchasers deposited 25% of bid amount on the date in conformity with Rule 9.3. High Court by its order of 15 December passed in CRP so and so held as follows. It is also open to the respondent bank to accept the balance sale consideration from auction purchaser, and however it is made clear that till the disposal of SA so and so by DRT Coimbatore, no further steps should take place. So, my lord, green signal was given by the High Court also in the SARFAESI sale. A plain reading of the aforesaid order makes it manifest that while the High Court permitted the secured creditor to accept the balance sale consideration, it consciously restrained the secured creditor from taking forward the sale to its statutory culmination. To construe the expression no further steps as barring receipt of balance sale consideration would render the first part of para 14 of the order dated 15 December OTOs. The restraint therefore could only have operated in respect of the subsequent and final stages of the process, namely issuance and registration of the sale certificate, which alone confer title. Any other interpretation would not only defeat the evident intent of the order, but also introduce an internal incongruity qua its operative directions. The borrowers in this interregnum continued to prosecute their statutory remedies. Applications under 17 remain pending and interim orders subsequent continued on finalization. Then, my lord, kindly straight away come to para 23. Statutory stipulation for completion of sale is the sale in favor of auction purchaser inchoate. While the rights of a bona fide auction purchaser and the sanctity of a confirmed sale ordinarily merit protection, such protection is not absolute and must yield where the sale process itself is shown to be legally infirm or incongruous with the extant statutory framework. In the present factual milieu, where the completion of sale was delayed beyond stipulated timelines due to judicial interventions and procedural constraints, and where such delay is not attributable to borrowers, the mere factum of confirmation cannot preclude judicial scrutiny. Well, in my case, it stands on a better footing because confirmation also had not taken place. The raison d'etre of the proceedings under the SARFAESI Act is not the mechanical completion of a sale, but the lawful realization of the secured asset in a manner that is fair, transparent, and conducive to securing the best possible value while balancing the interest of all stakeholders involved. If the process suffers from material irregularities or fails to conform to mandatory requirements, thereby rendering the sale inchoate, the court would be justified in intervening, particularly where the borrower has, in the interregnum, discharged the outstanding liability so as to obviate disproportionate deprivation of property and uphold substantive justice. Now, Lord, here Lordship has seen the timeline in between the months of January to March. Lord, in February itself, I have put in the entire money, written the letter of 18 February, because why, my lord? There was an inherent disproportionality so far as valuation and all these issues are concerned. My property of 147 katas was valued at peanuts and was being sold off. So, my lord, I chose the lesser evil. I have put in the entire. This is the maximum you can get. Well, this last line is very important, where the borrower has in the interregnum discharged the outstanding liability so as to obviate disproportionate deprivation of property and uphold substantive justice. So, my lord, it now becomes academic whether the valuation is correct or incorrect once I have put in the entire money. And once the money has been put in, the DRT and the tribunal is only to consider valuations and all that. Or, my lord, return my property. This is where I stand. 237. Well, I stand corrected. It's not 147, it's 237 kathas. The land is 237 katas. Well, kindly straight away come to, well, here, my lord, the surfacey rule has been quoted in para 25. And my lord, kindly straight away come to para 26, because under rule 9.4, my lord, specific timelines have been given by the rule. As evinced herein above, the statutory mandate is writ large. The balance 75% of the sale consideration is required to be paid within the time stipulated, subject to a limited extension not exceeding 3 months. Admittedly, in the present case, the auction purchaser had expressed willingness to deposit the balance amount as early as on 17 September. However, this was accompanied by a rider that the deposit be contingent upon the secured creditor's formal confirmation of the sale. However, it did not positively respond owing to the pendency of the proceeding within the period contemplated by the relevant rule. Instead, the deposit was made on 31st March, long after the outer limit under the statutory framework. Nothing prevented the secured creditor from accepting the balance consideration, not even restraining order of the High Court dated 15 December. In fact, the said order permitted the secured creditor to receive the balance consideration. The failure to receive the balance consideration or the delay in deposit of the balance consideration, whatever one would like to call it, therefore inures to the benefit of the borrower and operates against the finality of the sale. My lord, in my case, my lord, I have put in the money much before. So either way, it doesn't come in the way. A transaction which proceeds in violation of statutory timeline cannot be pressed into service for divesting the borrower of their secured assets. Crucially, the said delay is not attributable to any conduct on the part of the borrowers. Instead, the borrowers pursued other remedies available in law, and protracted pendency of such proceedings would not hold up as a justification to dispense with rigor of surfacey rules, especially when consequence sought to be enforced is the irreversible divestment of the borrower's secured assets. Then, my lord, the other cases have been quoted. Kindly straight away come to para 29. Matthew Verghese has been quoted. Kindly straight away come to paragraph 30, which should be, my lord, in print page 13 of the printout which I have handed over. So, my lord, I had read elaborately Matthew Verghese. Those portions have been quoted. And then, my lord, para 30. The principle enunciated in Matthew Verghese squarely operates in the present case. A sale that remained inchoate in favor of the auction purchasers, owing to non-compliance with mandatory timelines prescribed under Rule 9.4, cannot be invoked to defeat the right of the borrowers to redeem, especially when the borrowers remitted the entire remaining dues on 2nd September 2022. Nor can a belated plea of third-party interest prevail when the statutory condition for vesting the title were never fulfilled. Well, here, surfacey rules doesn't apply. When I had put in the money and written, it was inchoate because that by that time, my lord, nothing had been done. Then, my lord, kindly straight away come to paragraph 33. This should be in print page 15 under the heading Roman 3, borrower's repayment. The record, when read as a continuum and not in fragmented silos, leaves little room for doubt that borrowers had, by successive payment made under judicial supervision, brought the outstanding liability to the brink of complete extinguishment and stood well within the reach of redeeming the secured asset. As reflected in the notice issued under 13.2 dated 10th February, total outstanding was 3 crore 89 and odd. Pursuant to orders passed in proceedings before DRAT that followed, borrower deposited 75 lakh as pre-deposit. Upon modification of High Court, further deposited 35 lakh on 15 January. Thereafter, in compliance with subsequent direction, additional sum of 85 lakh was deposited. My lord, kindly notes all are deposits pursuant to court or preconditions of preferring an appeal. When applications under section, consequently, even prior to 31st March, when application under section 17 of the borrower came to be dismissed, the outstanding amount stood reduced to approximately 1 crore 95. When the process of repayment by the borrowers did not halt there, when the writ petitions relating to the impugned judgment before us were entertained by the High Court, the borrowers were directed to deposit the entire balance amount within a week. That is the order dated 28 November 2022. This was also pursuant to orders of High Court. In compliance with the said direction, the borrowers remitted the entire remaining dues of 2 crore 29 by RTGS on 2nd December and addressed a contemporaneous communication dated 2nd December to the secured creditor seeking acceptance of payment and return of the original deeds. This is equivalent to my 18th February, which I had addressed to the secured creditor. The details of these payments are set out to the compliance report dated 2nd December and annexures forming part of the writ proceedings. The refusal by the secured creditor to accept the payment was not on the ground of any shortfall or default. This is very important. Lordship just heard the objection of my learned friend. There is no objection that it is short or it doesn't amount to satisfaction. Not on any ground of any shortfall or default on the part of the borrower, but solely on the premise that third-party interest by then had been created. Same is the identical objection raised before the fora below. And my both the fora and my interim reliefs were refused. Third-party interest created, process has been set in motion. We will not look into it. In a situation where the borrowers had, in fact, discharged the entire quantified liability pursuant to judicial orders, such refusal by the secured creditor accentuates the disproportionate consequence sought to be visited upon them and starkly brings into focus why divestment of secured assets of the borrowers in the face of well-nigh complete and ultimate full repayment cannot be sustained in law. This is very important. I read it again. Accentuates the disproportionate consequence sought to be visited upon them and starkly brings into focus why divestment of secured assets of borrowers in the face of well-nigh complete and ultimate full repayment cannot be sustained in law. Conclusion: for the reasons discussed above, we find ourselves in complete accord with the conclusion arrived at by the High Court that the impugned auction sale having not attained finality, qua the auction purchasers in the manner contemplated by law, and secondly, the borrowers in the interregnum having discharged the entire outstanding liability, they could not have been divested of the secured assets. So, my lord, para 35 is the answer. Lordship will go back once to para 10. Lordship sees the what were the questions framed. Para 10, if Lordship goes back at page 7. Whether an auction sale under SURFACE, once confirmed and followed by issuance and registration, can be annulled by High Court. In my case, there has been no registration, only issuance of sale certificate, that too nearly after a month I had put it in, and second where right of borrower's redemption survives. So, my lord, whichever way Lordships looks at it, my lord, general law under section 60 of the Transfer of Property Act, special law under the SURFACE Act, my lord, equitable right of redemption has always been recognized of that of a mortgager, because, my lord, otherwise it, my lord, in the language of the Apex Code, it is a disproportionate punishment. My lord, they have the luxury of sitting over, my lord, 30 crore, 40 crore property for 3-4 crores and they'll sell it and they'll say, I've got my money. This is where, my lord, I don't want to dwell on the unholy nexus. Lot of things go on. But this is not a case where, my lord, I need to dwell on that. It's a simple proposition, my lord. The list of dates, my lord, squarely, my lord, shows the factual scenario. My lord, one more judgment apropos the objection raised, that whether a deposit can be treated as a satisfaction by the creditor, because, my lord, submissions were made on the last occasion that you have deposited in court. The creditor has not seen the color of money. So how can you say that it's deposit to the creditor? Now, my lord, for this, kindly straight away come to paragraph 21 of this judgment. My lord, this is again under the debt recovery law. And this is also a deposit, my lord, when appeal was preferred to DRAT. Same argument was advanced. The appeal under section 18 of the Act is permissible only against order passed by DRT under section 17 of the Act. Under section 17, the scope of inquiry is limited to steps under 13.4. Well, this is surfacing. The partial deposit, therefore, the partial deposit before DRT as a precondition for considering the appeal on merits in terms of section 18 is not a secured asset. It is not a secured debt either, since the borrower or the aggrieved person has not created any secured interest on the pre-deposit in favor of the secured creditor. If that be so, on disposal of the appeal either on merits or on withdrawal or on being rendered infructuous, in case the appellant makes a prayer for refund of the pre-deposit.
Last portion of the paragraph.
Yes.
Yes, placitum H, just 2-3 lines above placitum H.
But with, well, the important line is
If
on the
that just
request of the secured creditor,
Yes.
but with the consent of the depositors had already appropriated the pre-deposit towards the liability of the borrower, or with the consent had adjusted amount. Well, consent I have already indicated. When I am writing the 18th February letter, I am indicating my consent that you are at liberty to appropriate the fixed deposit, the deposit which
there is a consent, this deposit amounts to payment.
amounts to be done. And, my lord, the last judgment which I cite, because, my lord, it's a 227 and lordship wanted to know the extent of my lord's powers, because, my lord, this is at the end of the day coming from orders of refusal of interim orders, where the list at large is before the two tribunals bureau. My lord, kindly have a look at this judgment, para 62. I have given my learned friends a copy.
It is also reported. 2000.
The lordship can also take down. I have got it. Lordship is aware of.
Well known.
This is reported in 2010 8 SCC 329. Just one paragraph for my satisfaction. Para 62, clause G, which should be, my lord, at Shobi to 4 hoega. Kindly straight away come to para 62.
Patent perversity.
Yes. Paragraph G.
Gross manifest or failure.
Apart from situations pointed in E and F, High Court can interfere in exercise of its power of superintendence when there has been a patent perversity in the orders of the tribunals and court subordinate to it, or where there has been a gross and manifest failure of justice, or the basic principle of natural justice have been flouted. But already I had shown in these judgments, Matthew Varghese, which has quoted, right to property recognized as a constitutional right and all this. Here, my lord, I am crying foul from day one. Interim orders refused only on technical grounds. And in the meantime, my lord, they are putting forward the purchaser everywhere and saying special equity, special rights have been created. These special rights of a third party stranger cannot take away my constitutional right and right of redemption, which has been recognized to survive till such time a deed has been executed. My lord, in that view, my lord, lordship will exercise my lord's power under 227 and kindly do justice. And my lord, my valuation ground also is there. If lordship wants, I can argue. But since I have already put it in, it is academic.
Will be there before the tribunal to decide. You want a
Because, my
status-
lord, I must be very candid. I don't want to go back to the debt recovery tribunal. The reason being, my lord, it's a tribunal.
Your 30 appeal is pending there. That
Correct, correct.
There
But, my lord, if lordship holds, if
right of redemption.
my lord, so far as my
Since the appeal is pending there.
no,
you
my
cannot
lord,
decide.
I am on a more fundamental point. My lord, that is why I cited this judgment. If lordship holds my right of redemption is there and it is surviving and it has been validly exercised, then, my lord, DRT cannot overturn it and, my lord, has to follow. I
exercise will definitely be done by the DRT in the section.
No, my lord,
appeal because that is also
my
the
lord,
scope there.
My lord, lordship was few days ago on this side. Lordship has more experience what transpires in debt recovery tribunal. I don't want to elaborate, but I am on a fundamental question of
you now. If I am with you now, you'll be protected by an order of status quo in any case.
my lord, protected by order of status quo means, again I go back there, I suffer the same fate.
I cannot usurp DRT's jurisdiction and decide section 30 appeal here. That will be
My lord, that is why I relied upon, my lord, the latest Axis Bank case. I am sorry, my lord, 2026 judgment of Justice Dotto.
But there the cycle was complete.
My lord, lordship is here.
Cycle
My lord, lordship is here exercising not, my lord, 115 under the Civil Procedure Code,
know, but
but 227, which, my lord, in other high courts, why in other high courts, Supreme Court is saying it is nonetheless a writ jurisdiction. 227 is also a writ jurisdiction. Over here, my lord, in Calcutta, we have this special, my lord, it's a bifurcation of 226 determination and bifurcation of 227 determination. That is,
but there are Supreme Court judgments on this also saying that 226, 227 are basically different in scope.
Well, I am not saying 226 and 227 is the same. I am only saying 227 is also a part of the writ jurisdiction where, my lord, that is why I cited, this is a case under 227, that manifest injustice, and if lordship sees patent perversity, lordship will exercise 227. And, my lord, these propositions of law, my lord, what I have cited, my lord, I may argue the same thing in DRT. I suffered the same fate. And then, my lord, again I have to come up. That is what, my lord, my apprehension is, my lord, lordship will protect me. A simple order of status quo may not, my lord, adhere to my benefit because my lord, of these. And, my lord, in the event lordship is inclined only for status quo, provided lordship accepts whatever I have submitted, subject to hearing my learned friend, my lord, then also I would submit, my lord, lordship would make it clear so far as the proposition of law is concerned. Otherwise, my lord, injustice happens in the to and fro from DRT to High Court and vice versa. And, my lord, all this time, my lord, they will carry the baggage of this. My lord, the purchaser is there who is buying a 100 crore property at 10 crores. Let us say at 10%. They will tom-tom the purchaser everywhere and say, look, he has been deprived for so many years. This is exactly because, my lord, today, my lord, the bank should have returned the money of the purchaser and should have fought it because the money is there. This is what, my lord, I want to show. That is why, my lord, even before your lordship, my lord, the bank was more keen to put the purchaser in the forefront. My lord, in my respectful submission, the purchaser, my lord, and if bank delays the release of the money, my lord, they are supposed to return the purchaser's money with interest, not other way around. And this is what the bank deliberately does, my lord, which this mischief we are trying to prevent.
Delay will create equity in their favor.
Because, my lord, this length of delay, which the bank is deliberately trying to create by not refunding the purchaser's money even after this, my lord, it's a desperate and deliberate attempt to create equity in favor of the purchaser, which no law recognizes.
Yes, thanks.
May I come back on after tomorrow? Consider this judgment, I'll come back after tomorrow, anytime, my lord.
I hope that tomorrow because my learned senior friend has relied upon the list of dates.
Yes, that I have to verify.
Exhibit in support
Yes,
thereof. I'm carrying the
I have to verify that side.
Corroborate with, and essentially, my lord, all of the dates relevant. I must concede very fairly. Right of redemption is a fundamental. Statutory right originates from section 16 of the Act under general law and section 13(8) under Service Act. But, my lords, the validity of these dates are very essentially
But kindly give me leave to file the records. I have got it. I have
One more point I would like to.
No, I don't want this, my lord. Allegations, I don't want. I have got it. I don't submit without seeing records.
One more point I would like to argue before your lordship.
When can you come back? Tell me then.
Any day, next Monday, nahi.
Monday will be.
He is appearing for the purchaser.
कभी दिया
ये दीदी मंडे तो अनेकগুলো আছে বোধহয় না मंडे we have
Monday Tuesday any day
The purchaser's voice is louder than the bank.
That is okay. নিমেশ দা আস্তে করে কথা বলতে পারবেন
আমার গলা এমনি আসতে
কালকে কি হবে 2 pm
কালকে
আচ্ছা কালকেও আছেন
any day next week
আর ডিআরটি রেকর্ডস তো সবারই কাছে আছে দে ক্যান জাস্ট ভেরিফাই কোন ডেট ভুল হয়েছে কিনা
ঠিক আছে শুক্রবার কিছু রাখিনি
জাস্ট ডিআরটি রেকর্ডস
শুক্রবার তো অ্যাসাইনমেন্ট
চেক
পরের শুক্রবার ওই দিন কিছু নেই
টাকা তো ঢুকে গেছে আমি যদি আজকেও কোর্টে এসে টাকা দিই আজকেও হবে
ফ্রাইডে নেক্সট ফ্রাইডে নট দিস ওয়ান ফ্রাইডে উইক
কবে হচ্ছে ভেরি গুড
if lottery permits
2 pm fix
ফ্রাইডে লিখে নিন heard Mr. Chaudhary, learned senior advocate.
Mr. Mishra can come later. Then hear the bank and then if
15th you are in difficulty, Mr. Mishra. Then we are approaching vacation.
No, my lord, the entire, my lord, whatever, because my lord, lordship is also human, my lord, it is not possible to remember the dates and the contention.
And I'm slow also.
No, it's not a question of that, my lord. It's a, my lord, the impact goes away, my lord. I would beseech my learned friends to, my lord, whenever, my lord, at least, my lord, Mr. Banerjee for the bank, lordship.
Yes, I don't want to hear in piecemeal. I'll hear both of them.
15,
so that you
very
can
well, on
verify.
15,
No,
that's
but
all
he is
right.
in difficulty says.
15th, all right.
15th, what time is your matter fixed?
Lordship can prepone it. I have no problem.
And nonetheless, my lord, since my lord is heard my lord, the cause should come here. I'll come and request. I'll seek for 14 would have been more. 14th, 14th we have. I'll be having a division bench because I am a regular part of division benches also.
If my lord can accommodate us on the morning also, I am okay.
Yes, morning, I don't want to. This is a heavy.
Very
load.
well,
I'll be accused.
I understand.
motions
Then, my lord, I would request Mr. Mishra to be 15. Very well.
15th.
नाम लिख
এটা রেখে নিন দিদি কল করুন not today করে দিন not today করে দিন এখন কোথায়
13, my lord, I appear for the petitioner, my lord. Plaintiff is the petitioner before your lordship, my lord.
Caveat, no caveat. Take a caveat.
Caveat.
Caveat and Mr. Gopal Mukherjee appearing this matter.
Pass over. Next.
49 for the opposite party, caveat, my lord.
Pass over.
My lord, petitioner. 40.
Lord, this is Lord, mercy petition before your lordship. Lord, a suit for eviction was filed. Lord, my client lost up to Lord in this up to second appeal. Now, Lord, execution is going on. Police help has been ordered. Lord, since my client is residing there for more than Lord 50 years, we filed an application before the trial court. Lord, give us some time. We are giving undertaking. We'll vacate to give us an alternative arrangement. Court rejected it on the ground since there is no stay from the higher court. Lord, it is. Lord, this is Lord, more than 50 years Lord tenancy. Lord, this is some time we will make it.
Also, pending for when was the suit filed?
My lord, suit filed in 2013, my lord.
2013.
The decree passed in 2023, my lord.
Yes.
Well aware about the decree, my lord.
But
We have filed up.
I cannot argue. I have nothing to argue, my lord. I bear it upon your lordship, my lord. This is, my lord, what
My
is
lord,
there.
next date is fixed till fixed on 22nd of June, my lord. Till we have not.
2nd of June is the next date.
Next date.
The problem is this this petitioner's father had gone on knee surgery, unable to move. That is, my lord, if that can be 3 months, my lord. That is.
This is the same. This is the difficulty we also face, my lord. If the petitioner's father died, my lord, then the others subsequent proceeding will start, my lord. Kindly,
that is also
one of the petitioners.
We have lost up to my lord, division bench. My lord, nothing will.
One of the decree.
And my undertaking will be, my lord. I will be bound by my undertaking.
Kindly, my lord.
I have to file a
Supposes I cannot, then that becomes
Lord,
difficult. How
this
can
is,
I
my lord,
bulldoze it? You speak to him.
And I am speaking to him, my lord.
Make him agree because it has to be an order on consent. I cannot impose a.
Lord, the landlord is my learned friend senior only. Landlord is the advocate. He is my learned friend senior only. My lord, I have also requested my lord is senior also.
Then you speak with him. I'm making it not today. Come with some sort of agreement, a consensus of 1 month or whatever.
And I have to file undertaking, my lord.
And the consequences of breach of undertaking are
Definitely.
severe and serious.
Definitely.
So only if he agrees, there is no pressure. If you don't agree, I'll have to dismiss it.
My lord, this is what my lord. What
Not today.
July. Not today, my lord.
Not today. Because he in any case have time for a month, more than a month now. Because if it's on 22nd of June.
দেখে নাও কথা বলে নাও more than 50 years will at this lord this is lord
15 word I am for the petitioner, my lord.
Yes.
The last occasion. Well, may I seek for a very short passover, my lord? My brief is, my lord.
Passover.
Great.
চলুন নেক্সট এগিয়ে যান পাসওভার আর ব্যাক করবেন না এগিয়ে যাবেন পরে হবে এরগুলো নালে ধরা পড়বে আগে চলে চলুন
16 Your Lordship, I'm appearing on behalf of petitioner Lordship led by Mr. Thakkar, Your Lordship.
Not today. Next. যেগুলো ধরা পড়ছে না সেগুলো একটু
15 my lord will not.
Wait.
Yes.
Because there are others who are waiting in queue. Once you have lost your opportunity, I'll have to come back then. Wait. চলুন কল করে যান
99 for the person. My lord, yes, petitioner is a plaintiff in the suit, my lord. After filing the suit was filed for declaration and injunction. After filing the suit, the defendant number 1 and 2 filed application under order 14/2. And the plaintiff also filed an application order 6/17. Order 6/17, plaintiff also filed the application order 6/17. Both the application were heard together. Kindly come to the order of the improvement. The application order for the rule was allowed on the point of maintainability of the suit. There is no jurisdiction. This property is the Waqf property. Time of the jurisdiction, civil court have no jurisdiction. And decided the application order 6/17 on merit and rejected the city application. I have challenged the order of the rejection of the application.
But if an issue under Order 14, Rule 2 of the Code of Civil Procedure has been decided against you and suit has been dismissed, how is this revision maintainable? It's a decree.
Then why he decided the application order 6/17?
Whatever, but in that is an interlocutory order that merges with the decree. It becomes a decree.
If the civil court have no jurisdiction to decide any matter dispute, why that application should be kept
suit
pending?
itself has gone. Whether application decided or not decided is now immaterial. You don't have the suit. If you don't have the suit, then what is the purpose of having an application?
If the plaintiff should file before the Waqf tribunal, then they may seek for an amendment of the plaintiff.
Whatever, the suit is not there. So if the suit goes, all interim orders also go.
This is my suit, my lord. My suit is
your suit. So you should have challenged it by way of an appeal.
Appeal has been filed, my lord. The title appeal has been
Then
filed.
why have you come here unnecessarily?
I am challenging that.
Because the suit has to go, has to be restored only then.
Now, I am challenging only what is 6/17 order, my lord. Not
that you cannot now because it has merged in the ultimate decree of dismissal.
The learned judge have kept the pending
ultimate decree of dismissal. It has merged. This is not maintainable. Yes, next.
My lord, I'm appearing on behalf of the petitioner, my lord. My lord, the petitioner is a partially disabled person, my lord, against whom a suit for eviction has been filed. In such suit for eviction, I have filed a order 14 rule 2 application which has been rejected, and impugning that order, I'm before your lordship filing the instant civil revisional application. My lord, the fact of the matter is that the suit premises where the petitioner stays is a HON'BLE property, my lord. In a HON'BLE property, the government is the owner, my lord, and the recorded lessee, recorded tenant is the one Ram Mohan Datta and others, my lord. Sometimes about 80 years ago, the father of the petitioner was inducted in the property by the said Ram Mohan Datta, and the father of the petitioner used to pay rent to the Ram Mohan Datta in his Shrestha quarterly, my lord. My lord, the petitioner used to live in that suit premises with his father, mother, and his elder brother. My lord, brother, after he got married, he left the premises in 2002. My lord, thereafter, the petitioner and his two parents used to live there, my lord, and pay their rent to the my lord, the Ram Mohan Datta and others. My lord. Then, my lord, the father of the petitioner died in the year 2008, and the mother died in 2011. Till then, no issue has been raised by any other person, my lord. After they died, my lord, the petitioner, the plaintiff, sometimes in the year 2019, my lord, filed the instant suit for eviction, my lord. Which I have later come to learn that the suit has been filed in collusion with my elder brother, who is the defendant number 1 in the suit, my lord. But I didn't had had the knowledge at that time, my lord.
14 rule 2 sub rule 2 is for pure questions of law.
Yes, my lord.
The
Pure question
point
of
that
law.
you are-
It's already
the point that you are
dependent.
canvassing will
DW2
require evidence.
witness is going on.
Yes, my lord. My
The
my
point that you are
contention is
canvassing
that
will- the point that you are canvassing now will require evidence to be led. How
yes,
can that be decided?
my contention is that, my lord, while disposing of the order 14 rule 2, the learned court below has failed to appreciate that the learned court below has come to a conclusion that since a order 7 rule 11 was rejected, which was filed by my elder brother,
The reasoning may be incorrect, but
Yes,
that does
ma'am.
not necessarily mean that because of an incorrect reason, the conclusion will also be
No, no,
incorrect.
my lord,
Ultimately, what you have just now submitted from that I can make out that it's actually
I am trying
an issue for trial.
Yes, well, I'm trying to say is that I have contradicted the claim of the plaintiff with regard to that she is a Tika tenant of the property. She is not, because no such declaration has been made by the authority in her name. Secondly, she is not even the owner of the structure, my lord, and she is not my landlord.
Yes, but all these issues.
Yes, my
will be
lord. That
decided
is
in trial.
that is I want to say that this should be decided before disposing of the 14(2), my lord.
That is not the law. Order 14, rule 2, sub rule 2
yes, ma'am.
is for pure questions of law. Where on decision without taking evidence, the suit can be disposed of. Now, the point which you are raising, this point of yours, it will require evidence to be led.
Yes,
you
my
will
lord.
have to show.
Well, in that case, my lord, this petition needs to be not needs to be disposed of. It has to be kept pending. My lord, because
it will be an issue in the suit.
Well,
It
I'm
can't be
taking the
order 14
jurisdictional
rule
point on the ground that she is not even the Tika tenant, and the section 8 does not come into place until it is proven that she is a Tika tenant. And my lord, if I may.
These all points has been taken in this revision. Kindly see their written statement and everything.
Take your seat. Take your seat. Please take your seat.
Yes, ma'am. May I just read the section 8 of the Tika Tenancy Acquisition and Regulation Act? Yes, ma'am.
I can send it back saying that this issue will be decided at the time of trial along with other issues. That will help you.
Yes,
unnecessarily. Why? Because it cannot be decided as a preliminary.
I want, my lord, this point to be open, my lord.
Because it has to be open. It will not be decided as a preliminary issue. I will clarify that.
Yes, my lord. Yes, my lord.
My lord, one thing, my lord. Well, this issue has been first time taken before this honorable court. He has
He
got
is entitled to take it before the trial court also.
not taken in their evidence, not taken in their written statement.
My lord, it is
If he has not
As
taken
per
in the
law,
written
he can take. As per law.
whatever, this issue has been raised here.
Yeah, my lord, I have raised in 14.2 because it is my contention.
For order 14 rule 2
14,
sub rule 2
14 rule,
application.
yes, my lord. And my also
They are
my
not paid
reply.
off.
And also my reply, my lord.
They are now
So
claiming it is a
application
small property.
Because what happened is that, my lord, I have
My lord, one
entrusted
thing,
my
my lord,
fate
law has
upon
been
my
settled, my lord, that
Both of you can't argue at the same time.
I
what
pray
I
apology.
is that, my lord, I have entrusted my fate upon my elder brother. He assured me he will look
But
after
in
me.
your order 14 rule 2 sub rule 2 application, you have taken the same ground of a Thika tenancy.
Thika tenancy.
Tenancy, and in my reply also I have given, my lord, that I have stated it is a HON'BLE
So
property.
he has said that he has already dismissed your order 7 rule 11 application, which was
Yes, my
taken
lord.
out on this ground.
And my lord, order 7 rule 11, my lord, has not been filed by me, my lord, without my
At the
authorization.
time of trial, he
Yes.
can always raise this issue because this is an issue there.
Yes.
Order 7 rule 11 stage is just on the basis of the plain.
Yes, my lord.
It is not on the after leading evidence. His written statement will not be considered at that stage.
No, no, no.
Once he puts in the written
no,
statement.
the small portion I am not on the Thika tenancy.
No, he is
The
Thika tenancy only.
Thika tenancy only. My small is
because there is
small is different. Yes.
Already, my lord, eviction of trespasser can be filed. Only tenancy is barred.
This revisional application is directed against an order dated December 22, 2025, passed by the learned civil judge within bracket junior division, second court, Shialda, in title suit number 48 of 2019, whereby
274.
274. I am mentioning upon
267, my lord, the first we are present, my lord, for the petition.
I have given it, my lord.
Serially call for. My lord, for the petitioner, my lord, the order.
No, I'm in the next one.
Hey.
Lord, the last order is of 21st of April. My lord, we have, my lord, the order expires today. Grateful. Grateful, my lord, grateful. I'll send them a notice, my lord. Very well.
Lord, my landlord is there, my lord. It was last extended on 28th of April. Justice Mitro extended it till today, my lord, the interim order. My lord, may my lord fix it any day. Limited and extend.
It was granted back in the 20th of May 2025. After that, the matter has been languishing in the list, my lord. It has been only mentioned for the purpose of extending the stay, my lord. The point of law is very innocuous, whether in case of 7 months C for paying ongoing rent under the West Bengal Premises Tenancy Act, the extension clause under 7(2) can come in aid or not.
We will satisfy your lordships. The notice of eviction was given on the ground of reasonable requirement. There was no case made out. The plaint was not served. Document was not given. Chamaria will not apply. Chamaria will not apply in this case.
Seventh-day Adventist is very clear on this point. My lord, can you fix this?
Chamaria will not apply in this case. We will try to satisfy.
Lord. He cannot calm me, Lord. It is there.
My lord, let there be a, my lord, short extension and lordship will take up the matter any day.
I'm appearing for the petitioner below.
Any.
Third affidavit of service. Since beginning. My lord. I'll come tomorrow. I'll come. Hey, you did affidavit. I'll come
Yes, opposite side. But just a minute, but cannot stand for
My lord, read by Mr. Chatterjee, my lord. Required for the
limited period, my lord.
limited, short, my lord. Bracketing application is pending, my lord.
My lord, 15 days, maybe, my vacating application is pending, my lord.
Nearby, before, but 15th of June, interim order till grateful. নাম দিয়ে দিচ্ছি
স্যার আমাকে দিয়ে দেবেন
দাদা কোথায়?
They had said that we have to disclose. So we said that this is not permissible under the law. Still, then the arbitrator passed an order against that this 227 was filed, in which there is an interim order. So it has to be heard out. Lordship keeps it any day. Let it be extended. Keeps it any day, my lord.
I'll only pray that a shorter date may be given.
Yes, I have no issues.
Itself,
Whenever lordship wants, I will not stand.
any day, your lord. But take, I believe.
I don't stand in the way, my lord. Whenever lordship wants to fix it.
Yeah.
May 20. No, but May 20, I have a difficulty. 1920, except that any date lordship keeps, earlier or after that, any date.
Lordship will kindly keep it any.
1920, I'm not there, my lord.
19th in that even.
19th and 20, I'm not there, my lord.
18th, my lord. 19th, my lord.
Or keeps it on the reopening day, my lord. I have no issues. 9th. 9 June, I'm there.
Lordship, kindly appreciate what is happening during the arbitration.
Nothing is happening. My lord, cross-examination of my witness is going on, which she is doing. I'm not opposing.
Lordship, it will take.
Yes, 9 June, I'm there, my lord. Grateful, my lord. Grateful. 9 June. My lord.
This is my application, Lordship. Lordship, yes, 276. Lordship, the interim order was passed on 18th of June, Lordship. It's expiring today.
Madam, I am for the opposite party, madam. Madam, my only submission, madam, let the interim order be extended, but a date be fixed for hearing, madam, it is pending since.
Very well, Lordship. I do not have any objection.
My lord, instead of 18, my lord, any other day, my lord, any day, my lord. Yes, madam.
Lordship, I'm so grateful, Lordship.
My lord, I am for the petitioner, my lord. No one is appearing for the my lord, opposite party, my lord. The affidavit service filed earlier, my lord. The interim order will expire, my lord, tomorrow.
This is 210.
And I am for the petitioner, 217. Tomorrow. I'm for the petitioner, my lord. I've already served, my lord. I guess today they will. Tomorrow.
My lord, I am for the petitioner, my lord. The interim order has expired on 30th.
84.
The interim order has expired on 30th April.
Call all the 83 I am for the petition. I have served. Let it be written its position. I am for the petition.
Milord, I also filed a CAN application, Milord, for extension, Milord. Milord, let it be extended, Milord, a date be fixed for hearing, Milord. CAN 1 of 2026.
That's it. It is. Yes, I am the complainant. No,
No, madam.
Malad,
1A, 1B.
1A, 1B. Yes, yes.
Allowed. That is allowed. I have.
Complaint was
I have.
allowed.
I
They
prefer
preferred
appeal.
an appeal.
I have preferred
Appeal was
before
allowed
this,
by a bench having
single member.
The can was filed within time, my lord. Yes. Only one opportunity. Only one. Grateful. Grateful enough.
My lord, I'm for the petition of this matter, my lord. Today the interim order is going to expire, my lord. This is my predicament. And I've served the other side, my lord. Can you extend them? But today the interim order is going to expire. That ex parte hearing has started, my lord. Then tomorrow, my lord.
My lord, I am for the petitioner, my lord, in this matter. My lord, interim order will expire today, my lord.
My lord, this is my petition. 289, I appear for the opposite party. My lord, it's a short point, your lordship, if
We'll
can
take it up
indicate.
any day, but for today, my lord, will kindly.
Your
extend.
lordship may extend the interim order, although there is no application for that. But your lordship kindly
Need to,
fixes.
my lord, it is expiring today. So, my lord, I do not need to file.
Your lordship would kindly fix up a date, my lord. This is a very short point involved, my lord. My lord, 17, 1 and 2, whether the court has the power, my lord, to go beyond the statute to extend the time to allow the defaulted money to be put in before the
My lord,
court.
this is my petition. My lord, what I am aggrieved with is, my lord, my defense has been struck off by the learned trial court by applying the principles of West Bengal Premises Tenancy Act of 1997 when the tenancy is actually regulated by the 1956 Act. So, my lord, there has been an improper exercise of jurisdiction, and my lord, wrong principles of law has been applied.
My lord, both are arising out of the same suit, my lord, 289 and 290. If your lordship.
Two different orders.
June. 16 June.
I'm so grateful.
My lord, fairly at the top, my lord, if as new motion, my lord. New motion. Deeply obliged. Yeah. Deeply obliged.
291, my lord, I am for the petition. Interim order, my lord, already.
टू 92 दीदी 292 तो 91 तो पास ओवर होएगा तो बोले ना but I appear for the petitioner. But this is a very short issue. It can be disposed of right now. But a non-commercial suit, my lord, the written statement was filed on the 122nd day. That's the only point.
No, my lord, there is a conduct issue. My lord, court has looked into the conduct of the party that you have given a several chance, despite that you have not filed, and has refused to accept the written statement. However, I may say, my lord, I will take instructions. My lord, kindly keeps it day after tomorrow. If I can concede to the with some cost, if they.
But it's if your lordship is willing to give cause, my lord,
It's the day after tomorrow.
but only kindly extend till that day, but the interim order is
Nothing will
expired.
happen on the next day. But I'm saying that I may concede to the acceptance of written statement.
Grateful, great, great. Day after tomorrow, my lord.
They accept for a expedite for you. Friday. Tomorrow. Kindly keeps it as to be mentioned also, because I will be accident making not much argument. Day after tomorrow. Then yes. Well, I will not, because I've seen there is acceptance of written statement. I'm also liberal on it.
Grateful.
My lord, I am appearing on behalf of the petitioner, my lord. My lord, related with
But I'm opposing. I not today.
I appear for the petitioner, my lord. My lord, state is the other side, my lord, and now in view of the, yes, my lord, it's a land matter, specially assigned matter, my lord. So, my lord, therefore, we could not, my lord. My lord, otherwise, my lord, it's already 4 and it was fixed at 4, my lord, the interim orders. But this is, my lord, we have. No, very well. Well, tomorrow, lordship, I'll. Well.
I'm opposing this to him.
Well, the interim order expired on the 30th of April. We had filed the application.
Lordship,
I am on behalf of the opposite party. Lordship, this matter has a checkered history. That's why your lordship, we filed an
Your
affidavit in
lordship may,
opposition also. If Mr. Shah allows me 1 minute, your lordship, to indicate, your lordship, there are orders passed by the Honorable Supreme Court. Lordship, to dispose of the suit.
There is, in spite of all
Now,
that,
this matter, your lordship, when it's moved at this just at 4:30, direction has been passed that the matter to be heard on 12th March at 2. No steps have been taken.
The court did not sit on that date.
Thereafter, no mentioning notice, we mentioned the matter.
Very
Now,
well.
lordship,
What is the matter? What is the
There is a partition suit. In that partition suit, one of the
now,
issues.
once the Supreme Court, your lordship, has given a
May I
directive.
just tell your lordship? In a very, in a brief nutshell, there is a partition suit. There is a preliminary decree of partition. After that, there has to be a final decree for partition by meets and bounds. A commissioner has been appointed, but before the commissioner was appointed, one of the issues raised before the court was that so far as the flat is concerned, flats are concerned which are to be partitioned, there was a mortgage subsisting. Now, we have redeemed the mortgage. Under the provisions of the Transfer of Property Act, we are entitled to the benefit of that redemption. Either they have to compensate us with money or they have to compensate us with area. So we wanted that issue to be ultimately decided. But without deciding that issue, the Commissioner of Partition has been asked to file a report. It is in these circumstances we have to come up with a revisional application, and your lordship is pleased to pass the interim order. Well, I am only saying that the two issues are connected. Well, unless the issue of my compensation on account of the redemption of mortgage by
when
me
is the next date in the suit?
11th May.
11th May. 11th May. Well, a final report should not come. That is all that we are saying. If the final report comes, then the whole application will become infructuous.
But there is a direction from the Honorable Supreme Court to dispose it off within 4 months.
Yes.
Because of this
that was before the preliminary decree. That has happened. That is over.
No, lordship. Kindly see, your lordship, the order passed by the Honorable
I
Supreme
am
Court.
not standing in the way of disposal.
But this report will definitely lead to the disposal. If the report is delayed, then the
now,
disposal
today the difficulty is, can the report overreach the law? Now, if there is I have a right in law to seek adjustment.
What is the date for?
Well,
filing the report of
for commissioner to file the report.
And what is the order?
Well, no final decree will be passed till the 30th.
Correct. Your lordship, the report, the final decree will not be passed. Now, your lordship, 2 orders passed by. Honorable Supreme Court as well as your lordship in a criminal contempt jurisdiction that they should not, your lordship,
Supreme Court has nothing to do with this.
No, no,
Matlab,
certainly with
they
this.
have-
Kindly see the Honorable Supreme Court's
Why
order.
don't we hear this then?
Yes, no problem.
I'm sorry, man.
We can hear it.
Yes, yes, certainly.
Tell me when.
Well, kindly
As
hear
your
it.
lordship thinks fit, your lordship, Mr. Shah is there.
Very
your
short
lordship.
point.
Any
according to-
date, your lordship.
Any day, you tell me the date.
Well,
I'm
kindly
there
hear
every
it
day.
on Friday if it's convenient.
Friday, I'll be having assigned matters.
Then, my lord, after that, my lord, Monday we are on the 10th.
Yes, yes, tomorrow, your lordship, Mr. Mitro is.
Well, tomorrow I am not in Calcutta, my lord, that is the only difficulty.
If you all can agree, we can have it on 12th or 11th, whatever.
12th.
Well, we can have it on 11th or 12th.
11th, your
My
lordship.
lord, only
as
problem is,
Mr.
my lord, on that day the court should not proceed with the matter.
Lordship, I don't have any problem. 11th or 12th, whatever your suits, your lordship, Mr. Saha and
My lord,
Mr.
one day, my lord,
Honorable
court should
Court, your
accommodate
lordship.
us so that we can have the matter heard out. It's a very short point. Very short point.
13th.
My lord, for one day, my lord, the 11th is the returnable date. My lord, for that one date, my lord,
That day, you please take an adjournment on 11th.
My lord, on that day we will take an adjournment, my lord. There is no issue, my lord. But lordship kindly fixes the
Yes,
date.
yes.
I'm fixing it.
Yes, ma'am.
I'm fixing it. I'll hear it out.
Yes, ma'am.
So that I can utilize the vacations for writing the judgment if need be.
And your lordship kindly sees, your lordship, even we don't require to take an adjournment because the order says that the final decree will not be passed.
My lord, it is not that, my lord. Final decree, my lord.
You take an adjournment on that day. That is.
We
I'll
will
report.
take. We will take, your lordship.
Well, kindly extend the interim order till that date.
He says he'll take an adjournment. So.
My lord,
This serve your
kindly
purpose.
record it, my lord, that he'll take an
I'll
adjournment.
record that.
Yes.
I'm recording
Yes,
that.
yes, your lordship. Kindly record it, your lordship. This matters kindly record.
As jointly suggested by the parties, list this matter for hearing on Didi Kundin 13th. 13th at 2 p.m.
13th at 2.
On May 13, 2026 at 2 p.m. Full stop. Mr. Sengupta, learned advocate appearing for the opposite parties.
1 to 4, my lord.
Opposite party numbers 1 to 4. Fairly submits that the opposite parties shall seek an adjournment of the proceedings in case, the same are taken up by the learned trial court in the meantime.
I'm grateful.
Article 29, I am for the opposite party number 3, my lord. My lord. Copy. My lord, I'm not standing in the way of interim extension, my lord. Kindly fix a date. That's because we are suffering for interim order, my lord.
10th March 2026, my lord was pleased to.
It was restored because after 10 years.
Yes, without considering our objection
My
to
lord.
section 5 application. Should
My
not
lord,
be-
I will show.
Having heard the learned advocates appearing for the respective parties, the नहीं होता. Next.
So that I am for the petitioner. 17th February order, my lord, extend on 24th March, lastly extended on 27th April.
Lordship may keep this matter any day for hearing. This is
After vacation.
but if there is
Hands are full before vacation.
but if your lordship kindly hears me, this application, a third party, complete third party to the arbitration has obtained a stay of the arbitration at the final stage. And we had applied for vacating. Affidavits have been exchanged subject to your lordship receiving. Lordship had already fixed the matter when your lordship was not there. When it was fixed on 17th of April. We didn't know, or lordship also didn't know. Yes, so there is one impending urgency. Yes, that is true. No, that we are not agreeing to. But lordship may please any day before the vacation, because there is actual urgency in this. If a lordship could fix a time, it may not take very little time or may not take much time as well. Because the situation is a third party has come and installed my arbitration. Yes, I just saw. 19th is fine. Lordship may hear the matter out, then lordship will have the vacation as a lordship indicated. 19th will be fine. 21st we understand. Because the situation is after the stay was obtained, we had preferred an SLP. The Supreme Court granted us liberty to apply for vacating here before this court. We have applied for vacating. We had also asked for vacating of the order, partial vacating of the order, which because my learned friend wanted to file an affidavit to that, so we did not press for it at that time. That is why lordship had kept the matter on 17th April at 2 p.m. 20th April at 2 p.m., which could not be taken.
Yeah, my lord.
There's already there is a delay on their part to file it, but I'll not come in the way of that. We have also prepared our reply. It is ready. It is not a factual question. It is only a point of law which is to be considered.
Third party, another third party. I am not third party. I am the party. The third party is proceeding with the arbitration, representing me.
Arbitration is between opposite parties,
It's a
and the
question of
petitioner has come and stalled the arbitration and obtained an order of stay. And his application was dismissed. His application was filed before the arbitrator. That was dismissed in January. Thereafter, they approached this court on civil revision, challenging the arbitrator's order and obtained a stay. Though they prayed for no final award can be passed, and the entire arbitration has been stayed. And it's at the final stage. Entirely collusive proceedings, but I'll indicate all. Right. 19th. Wait for it. No.
301. My lord, the interim order has already expired. I have mentioned on notice, I have served, my lord. The final decree will be drawn up any day, my lord. Item number 301. My lord, there is no existence of other side as of now. Interim order has already expired, my lord. Yes, your lordship. Yes, I know that. I will come back tomorrow.